And are you wanting to have contact with your daughter?
Yes, ma'am, definitely.
All right. So now the case has been dismissed. You'll have unrestricted contact with her. So I don't have any. All right. That's my that's that's a live stream. I'm trying to get back to it. I hate hearing myself replay. There we go. Okay. I have to mute that in order to not hear myself replayed. Okay, so the case has been dismissed. Please be mindful that if there are any issues that you all need to work on with Miss Jada, then go ahead and work on those issues if it means counseling or some other thing that you need to do so that you all can have a harmonious situation, okay?
Yes, ma'am. Thank you.
All right. Well, y'all are excused at this time. Miss Jada Moore is excused at this time.
Thank you.
Ma'am.
Thank you.
Thank you, Miss Bain.
All right, and Miss Moore, just remember you don't want to have these types of situations. If y'all need if you need counseling or anything like that, go ahead and seek that out for me, okay?
Yes, ma'am. I've been in counseling since August. No, yes, since August. So we've been on the right track.
Okay, great. I love to hear that. All right, thank you.
Thank you.
All right. Next is Leva Yosleski Ruiz.
Yes, Your Honor. Attorney Tortorello, Lister Holt, and Dennis. Miss Reese should be in the courtroom. Is that right, Attorney Lynch?
She is in the courtroom, and the interpreter gave me a message to call the number when we're ready to go forward on the motion. Just wanted to go ahead and put that out there.
Okay.
Yes, Your Honor. That's going to be a motion in limine and a motion to suppress today. It's on your February 2nd trial calendar.
Okay, so now motion in limine just means a pretrial motion. What's the nature of the motion in limine?
It's the issue is the confrontation clause, Your Honor. There was an interpreter that was used to obtain statements from Miss Reese, so we're challenging the interpreter and the confrontation clause issue.
Okay. All right, and the next case is Devontavious Cortez Smith.
Yes,
Judge, Mr. Smith is in the courtroom.
Your Honor, we're withdrawing that motion.
Thank you.
Right. So the motion to withdraw bond to revoke bond has been withdrawn.
Did you want to address Mr. Smith before I excuse him?
No, just remind him of his bond conditions.
Okay.
Well, actually, who's the alleged victim? Like, what's their connection?
Judge, it's in the most recent case, Judge, the alleged victim is a previous partner that he has. They're no longer together, Judge. So it's a previous.
Yeah, bring him up. Bring him up for a minute. So, Mr. Smith, let me caution you, sir. So the state is withdrawing a motion to revoke bond, but if there are issues where you are violating your bond conditions, particularly the condition to not have contact with a particular person. Now, I know there are situations where the alleged victim will reach out to the person who's before me. If in those cases, if they're reaching out to you, then you go ahead and write down the contact, the information, keep a record of it, share that with your attorney, but please do not respond. Okay. But what I say to you is you're the person who is under the order of the court. And that being the case, if you were to have contact with the person that is prohibited, then you would be the person who could have your bond revoked. You would remain in jail until all of your cases are resolved. You could also have additional misdemeanors charged against you or felonies, particularly the felony of aggravated stalking, punishable by up to 10 years in prison, a $10,000 fine, or both. Do you understand? So it is very, very, very important that you, if you don't have your bond conditions, get a copy of them before you leave this building, read your bond conditions, and follow your bond conditions. Are we clear?
Yes, ma'am. Yes, Your Honor.
All right. So you're
Thank you,
free to go
Judge.
at this time. Thank you. All right, so it's my understanding that Ms. Bing and Mr. Hicks need to talk regarding the cases, and then we'll have a motion hearing on the Ruiz case.
Your Honor, also Miss Alicia Reel is on the line. She's on the 11 a.m. calendar.
Okay,
I have already filed a notice to withdraw the motion to suppress, but she's also expressed that she does want to get a private counsel.
okay.
And-
Well, then let me talk to her at the 11 o'clock calendar if it's going to involve more than you just withdrawing the motion.
Okay, Your Honor.
All right, so Ms. Bing and Mr. Hicks, I'm going to put you in breakout room number 1, and I'll be right back.
Mr. Tortorello, do you want to speak with your client?
No, not at this time. I just need you to interpret the hearing.
Okay, it's going forward. Is next.
Yes. It's the only one for this calendar.
Okay.
Thank you.
Your Honor, we're done with our conference, so whenever you're ready.
Right, are we ready to go forward with the motion? We have a response on Mr. Dent's case.
Yes, Your Honor, I believe we worked out an agreement on Mr. Dent's case. It
All
was
right,
all
is he ready?
underlined.
Is he ready to take a plea, or tell me what's going on?
We were gonna ask to
You keep going in and out on me, Mr. Hicks. What now?
do by plea in absentia, Your Honor.
Oh, so I'm hearing plea in absentia. I'll give you 30 days to get that done. And we'll lift the bench warrant. So we'll do a bench warrant set aside, plea in absentia on all three of the Dent cases, and we'll give you 30 days. Is that can you hear me?
I can, Your Honor. That sounds perfect.
All right, thank you.
Thank you very much. And may I be excused?
Yes, sir, thank you. Mr.
Thank
Dent,
you.
you may be excused. All right.
Thank you, Your Honor.
So I think that was the only thing outstanding.
Morning, Your Honor.
Hi, Ms. Fitzgerald, how are you?
I'm good, Your Honor. I'm here for a motion also.
Yes, we're here. We're about to start the motion.
Okay.
So are we ready on Ruiz?
Yes, Your Honor, defense is ready.
All right, state ready?
Yes, Your Honor.
All right, so this is the matter of State of Georgia versus Leva Yosleski. use Lexi, I'm sorry, Ruiz, 2023 CR 02799. Ms. Ruiz is charged with DUI count 1, DUI less safe count 2, leaving the scene count 3, and improper lane change count 4. This is a motion to suppress and a motion regarding the confrontation clause. Ms. Ruiz is being represented by Attorney Tortorello from the law firm of Holton Dennis, MJ Tortorello, and the state is represented by Attorney ASG Bing, and the court is ready to begin.
Your Honor, at this time, I would like to, defense invokes the rule of sequestration for witnesses under OCGA 24-6-615 before opening.
All right, are there any witnesses that are here prepared to testify on behalf of the state?
I believe in, go ahead.
Officer Tippett here. He's not in here anyway. He's going to come.
He's here, actually. He's on as investigator Thimmett, and then Mr. James Gordon from GBI.
Gotcha.
Yes, ma'am.
Right.
That's correct.
I didn't see him.
So I'll put Miss who you calling first?
I'm sorry, Mr. Timmett.
All right.
Officer Timmett.
So Ms. Torella, do we need openings or can we just get right into it?
I would like to do an opening, Your Honor, because there's a lot of different issues, and I would
Okay.
like to address those before.
All right. Who are we? Who else is here?
Mr. James Gordon, I'm not sure that I'm going to necessarily need him, but I'm going to reserve him just in case.
All right, Mr. Gordon and Investigator Timmett, I'm sending you both to breakout room number 3. We will come in and call you to testify at the time that your testimony is required.
Yes, ma'am. Thank you.
Yes, Your Honor.
All right, opening.
Yes, Your Honor. We're asking this honorable court to exclude admissions and statements allegedly made by Ms. Leyva Ruiz under the Confrontation Clause. The state may attempt to introduce into evidence at trial the alleged admissions and statements my client made through a language interpreter on or about January 1st of 2023. Officer Timmett of the Clayton County Police Department allegedly used a language line to communicate with my client. Officer Timmett also used a language line to obtain Ms. Ruiz's alleged consent to field sobriety testing and to a state-administered breath and blood test. The language conduit rule allows for the statement of the translator to be regarded as the statement of the person.
I'm sorry, I'm here trying to interpret simultaneously.
Ms. Tortorella, we have an interpreter in court and you're going way too fast.
Sorry. Can she be, I'm not sure what she's getting, so I guess I'll pause.
Well, she's getting it. It's just that it's going too fast for her to interpret it.
Yes, Your Honor.
You need to slow down is what
The language conduit
Interpret.
rule allows for the statement of the translator to be regarded as a statement of the persons themselves, creating no additional layer of hearsay. This is in Lopez versus State 281 Georgia App 623 2006. However, prosecution must provide assurances that the translation was reliable. This includes providing defense an opportunity to question the translator herself to avoid a confrontation clause violation. This is under Ursulita versus State, Georgia App 623 2006. As far as suppression, we are asking Your Honor to find that there was no probable cause for a DUI arrest, as there was only presence of alcohol, and therefore for all evidence after the illegal arrest to be suppressed, as it is fruit of the poisonous tree. We are also asking this honorable court to suppress the blood test results Ms. Ruiz allegedly consented to. The implied consent warning that was read was misleading and confusing, and therefore impaired Ms. Ruiz's ability to make an informed implied consent decision. We further ask the court to suppress my client's refusal to take the state administered breath test under Elliott versus State 305, Georgia 179, 2019. The state asked her for both tests when she was read implied consent, but Ms. Reese provided her blood. If the state asserts that Ms. Reese refused the breath test, that refusal should not come in. To add, my client was not read her Miranda rights before she was asked to take the portable breath test, and therefore, we are asking the court to suppress the positive result. Therefore, we're asking this honorable court to exclude any and all statements allegedly made by Ms. Reese through an alleged translator from coming into evidence, as well as suppress the portable breath test positive result made without her consent and the blood test. Nothing further.
Okay, Ms. Bing?
A few facts about this case. This took place on the wee hours of New Year's Day, 2023. Officers were responding to a vehicle accident. There was a one-car accident where the car had skidded off into a ditch. No one was inside, but two women, one of whom was Miss Ruiz, were seen walking a short ways from the scene. When officers approached them, they only spoke Spanish. And the police report says that the defendant actually called the language line through dispatch. I'm sorry, I'm probably going too fast.
Yep.
You're okay?
Yes.
Okay, thanks. It was translated that she had been driving and that the car was deliberately parked in the ditch. That was what she told dispatch. She also had told dispatch that she had been drinking at a friend's house for New Year's Eve and that they had decided to walk home. The officers smelled alcohol as they spoke. They noticed bloodshot and glassy eyes. Fields were not fully completed because she wasn't following directions. And the blood test confirmed that she was at 0.199. I'm happy to consent to suppression of the PBT. That's fine. We can't use it really in trial anyway. However, the confrontation clause issue is not an issue. It's a non-issue. Ms. Tortorello rightly says that the language conduit rule, according to Lopez v. State, absent a motive to mislead, I'm quoting, under the so-called language conduit rule, absent a motive to mislead, distort, or some other indication of inaccuracy, when persons speaking different languages rely upon a translator as a conduit for their communications, the statements of the translator should be regarded as the statements of the persons themselves without creating an additional layer of hearsay. The defense, as part of their motion, said that the translator should be here to be questioned. However, in Lopez itself, it says at 625, literally, here, quote, here, the translator does not testify. So there is no reason to testify. The second case law that the defense also cites reaffirms Lopez. And the translator does not testify, and the court recognizes that she should not have to testify. So we would ask that the state would rule that the precedent in Lopez and Hernandez would that they've adhered to language conduit rule, and that you would dismiss the defense's claim that the interpreter is required to appear for questioning. Additionally, that PC was already met, according to Frederick v. State and State v. Sledge, that have said that an officer's observations that the suspect's eyes are bloodshot and watery and exudes an odor of alcohol is sufficient to show probable cause for the suspect influence.
All right. Are we ready to call witnesses?
Yes, Your Honor.
Yes.
Okay. State's calling.
All right. Officer Timmett.
All right. 1 second. Timmett, you can leave the breakout room to, you're being called to testify. Let me see. Investigator Timmett, you can leave the breakout room. You're being called to testify. All right. We're just waiting for him to come out. 1 second.
Oh, there he is. Okay. Officer Timmett, good morning. Can you hear me?
Yes.
Okay. Did you
Hold on just 1 second and I'll swear him in.
Okay.
All right, are we ready to proceed? Miss Sonia, you all be mindful. We have an interpreter and she has to interpret everything for Miss Ruiz. So please, interpreter speed, if you could. Remember to take breaks.
Robert 4 R4 89 4 Deal Bill.
I think another officer is on, so I'm gonna go ahead and mute them. But y'all send them a chat to tell them to make sure they're muted. Okay, so Ms. Fitzgerald, if there's any reason you need to take a break, just let me know. All right. So Investigator Timo, raise your right
Yes.
hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right. You may put your hand down. All right, Ms. Bing, you're a witness.
Good morning. Could you state your name for the court?
Investigator Rudy Timmett.
And what do you do for a living?
Currently work at the Macon Bibb District Attorney's Office as an investigator.
Okay. And where were you employed New Year's Day 2023?
With the Clayton County Police Department.
Okay. Were you post-certified?
Yes.
And what were some of your duties in that?
Duties at that time, if I'm not mistaken, I was a part of Sector 2 precinct. I was assigned to Sector 2 precinct as the traffic unit, and pretty much respond to calls day to day, more in line of any accidents, pullovers, things of that nature.
How long had you been on the force by New Year's of 2023?
By 2023, I want to say about 2 years.
2 years. And in those 2 years, had you done any DUI investigations?
Yes. I've done several DUI investigations.
Okay. Do you recall New Year's Day of 2023?
Yes.
Okay. Do you recall making contact with Ms. Ruiz that day?
Yes.
Okay. Can you just describe what brought you in contact with her?
Absolutely. So on New Year's Day 2023 at approximately 1:44 hours, we received a call of a vehicle accident near 6299 West Fayetteville. At the time when we arrived, myself and Officer Bolin arrived to the scene. We seen a 1999 Chevrolet Astrovan that was lodged in the ditch. At the time, Miss Louise was not at the scene of where the vehicle was at. The fire trucks, Clayton County Fire and Emergency Services, they arrived on scene. They explained that, hey, we seen two young ladies walking up the roadway, and from there.
Objection, hearsay.
Overruled. Go ahead.
Yeah, they said that they seen two women walking up the roadway. Again, it's 1 o'clock in the morning. So from there, I went ahead and investigate and see if that was the possible driver. From there, I ran into Miss Louise and her friend at the time, and yeah.
How far away was Ms. Ruiz from the scene?
Okay, somebody's got a hot mic.
I'm sorry.
Not you.
Please mute your device if you're not part of this hearing. That's very important. Thank you. Go ahead, sir.
I'll just repeat my question. How far away was Miss Ruiz from the scene when you encountered her?
Miss Louise was probably about half a mile away.
And so can you describe kind of what your contact was with her?
Yes, so she spoke Spanish, and I had to contact the language line that Clayton County that Clayton County's contracted through. Um, from there, I was asking her questions and was trying to ensure that she was, in fact, the driver of the vehicle, which she did confirm that she was in physical control of the vehicle and stated that she parked the vehicle in the ditch and she decided to walk home. When I was asking her questions in reference to where does she lives or resides at, she told me within the Griffin Hampton area. Again, all translated through the language line. And while speaking with her, I detected many indicators to include substantial and prominent odor of an alcoholic beverage coming from her mouth while she was speaking directly to me, as well as she had bloodshot red eyes and as well as glassy eyes as well. And from there, I began my DUI investigation.
Okay. How many times had you used the language line before? Was this your first time?
No, it's my first time doing a DUI using a language line, but I've used the language line multiple times.
Okay, and can you just describe kind of what the function of the language line is exactly? Like if you call 911, well, never mind. You're not calling 911. You're calling your dispatch. Sorry.
Dispatch. Mhm.
Yes. So yeah, just talk to me a little bit about that service.
Absolutely. So from what I understand, it's contracted with the county. So we contact dispatch and dispatch goes ahead and contacts the language line, gets you connected with them. There's some type of code or pin that we provide to them so they can establish services. And from there, while we're on scene, we have them on speaker, and from there they translate for us.
Okay. And so the person that is translating, they're not an officer or anything. They're in a
From what I know, no, they're not an officer. They're just what is it, linguist?
okay. And they're not, as far as you know, invested in the outcome of the conversation.
Say it one more time. I'm sorry.
So as far as you know, they're not invested in any of the outcome of the conversation?
You said they're not
Invested in the outcome of the conversation?
No.
Okay. So you said that they were contracted. So they are separate and apart from the police department?
That is correct.
Okay.
A third-party contractor.
Okay. Okay. Could you just rate on a scale of 1 to 10? This is just your impression. Scale of 1 to 10, how fluently that translator spoke English?
Objection, calls for speculation.
I'm asking for his impression.
Well, I
he's
think
not.
there's I'm sorry. I don't like the question, so I'll sustain but I think there's a different way to ask the question. Were you able to make yourself clearly known, make your questions clearly known to the interpreter, and were you able to understand the interpreter when they repeated information given to them?
Okay.
To answer that question,
Yes.
yes.
Okay. Did it appear to you that Ms. Ruiz understood the
Objection.
Again,
I'm sorry.
Can
I finish the objection? Sorry. It
Sure,
calls
go ahead.
for speculation as to what Ms. Reese understood. It's only
I'm not asking what she understood. I'm asking whether or not it appeared to him that she understood.
Your Honor.
This is a
Ms. Tortorello, actually, it's a fair question because it's the difference between not just knowing what she understood, but whether he could continue the investigation based on what he was receiving and what she was saying. So that's a fair question. I'm going to allow it.
Officer Timmett, Investigator Timmett, what did it appear to you that she understood?
Yes, she was giving feedback as well, and actually engaging with the interpreter at a point.
Okay. You mentioned that the interpreter was on speaker, right? So there's no video component. Is that correct?
That is correct.
Okay. And then you mentioned that, sorry, maybe you didn't mention this. Was the interpreter able to describe the scene as you were just, so for example, you mentioned that you were responding to a vehicle accident, that the car was in the ditch, right?
Objection leading.
Well, no, I'm explaining.
Clarify your question, Ms. Tortorella, overruled.
Yes. You mentioned that you responded, he was in the ditch. Did the interpreter also, was the interpreter able to, without you telling her what the scene was she able to ascertain or translate to you what the scene looked like?
No. That was all through my through myself. She was literally just asking the questions I was trying to relay to Miss Louise.
That was a little bit of a convoluted question. I believe your testimony, let me just do this. Let me just confirm that your testimony before was that through the translator, Ms. Ruiz said that she parked her car in a ditch. That was your testimony, right?
Objection.
That was his testimony.
That's a leading and somewhat like a cross-examination.
Ms. Tortorella, let her get through this, please.
Yes, Your
She's
Honor.
asking him to clarify. You're asking us to believe that the interpreter wasn't doing her job when she interpreted at the scene. So if you're going to ask the court to make a decision on that, I need to know from the person who was right there, standing there listening to it and in the middle of the conversation, what was going on. If you want me to make a fair assessment.
Yes, Your Honor.
All right, then let the questioning continue. Go ahead, Ms. B.
Yeah, so Investigator Timmett, it was I just want to clarify that it was your testimony that the translator did say, or that Ms. Ruiz through the translator said that she parked a car in a ditch. Is that correct?
I believe so, yes.
Okay. All right. Let's move on to the investigation, the DUI investigation. So once you determined that you had detected the odor of alcohol, you noticed her eyes were bloodshot and glassy. Was there anything else that you noticed at all, or did you begin fields at that point?
No. Started asking questions. I asked her where she came from. She said she was coming from a friend's house. Asked her if she, consumed any alcoholic beverages recently. She told me that she consumed one, and I believe it was Bud Light. Can I reference my report for the time?
Yes, absolutely.
Okay.
If you need to refresh your recollection.
Okay. She stated that she did consume one Bud Light at
Objection, Your Honor.
approximately.
He's reading from his report.
He's looking at me.
No,
He was looking down.
He asked to refresh his recollection. He did.
Okay, sir, you can refresh your recollection, but look up when you're making the testimony, okay?
Sure. Yes, yes, Your Honor. Like I stated, it was at 8 o'clock p.m. 2000 hours on December 31st, 2022,
Oh, that's when she said
that she consumed her
that she
beverage.
did. Okay, gotcha.
And from there, um, due to the totality of the circumstance, the vehicle being parked there, vehicle being parked in the ditch, her walking away, the odor of an alcoholic beverage, her red glassy eyes, I began conducting field sobriety tests, and based on the field sobriety test, she did poorly. She performed poorly on the field sobriety test.
Were you able to complete the sobriety test or no?
You mind if I reference my report for that?
Absolutely.
Uh, okay. So based on my report, during the horizontal gaze nystagmus, I wasn't able to assess any clues because due to the fact that she was gazing away from my finger multiple times after she was explained multiple times to focus on the stimulus, which was the point of my index finger. From there, I did transition over to the uh, walk and turn test and one leg stand test, where she did perform poorly on those.
At what point, well, did you place her under arrest that evening?
I did, yes, ma'am.
And at what point did you do that?
Immediately after conducting the field sobriety test and immediately after reading her implied consent.
You read her implied consent and then made the arrest?
Correction.
Objection,
I
Your
placed her
Honor,
under
that's
arrest and
leading.
then I read her implied consent.
I'm sorry, I couldn't hear
Objection,
you.
that was leading.
Overrule.
I'm sorry, could you repeat your statement once more?
Yes, I placed her under arrest and then I read implied consent.
Okay, gotcha. Right. When you read her implied consent, did you read from the green card or something
Yes.
else?
Yeah, the
You
green
did.
card.
Okay, and did you read for suspects that are over 21 or under 21? I mean,
Over
over
21.
21 or, yes,
Over 21.
okay,
And I confirmed her data. I confirmed her age.
okay. Did you offer to explain implied consent at all?
I just read it, verbatim. You can't really explain it to them. That'll be
Gotcha.
out of our scope to explain it to them.
Okay, so you just read it. Okay, did you do you recall when you read her Miranda?
Um,
Or if you
I
read her Miranda?
don't recall reading her Miranda.
Okay. At all. So from the arrest to do you remember interrogating her at all? Like once you got to the jail or?
I don't believe so.
Okay. You don't believe that you recall interrogating her, or you don't recall, which one don't you recall, the Miranda or the interrogation? Or both?
The interrogation portion.
Okay.
Can I refer back to my report to see if I added that on there?
Okay.
And Your Honor, I just would object to this because this has to do with the PBT. And I believe the state has already stated that they consented to the suppression of the PBT.
I didn't hear her ask anything about PBT. What she asked about was whether he questioned her after the arrest. So I didn't hear anything about PBT.
The Miranda issue has to do with the PBT. That's part of the, I'm just saying
That's what okay. The Miranda issue that you raised has to do with the PBT. But if she's asking if he questioned her. If he questioned her, Miranda would also come into play.
I understand that that's just not an issue for defense.
Okay.
Okay.
Miss Bing, she says she doesn't care about that.
That's okay, that's good to know. That's fine. All right, I think, was a translator still translating when you got consent for implied consent for the blood?
Yes.
So does that mean that you had the translator translate implied consent when you read it?
I don't believe I can't recall, but I know for a fact I knew better. That it has to be read verbatim English, whether they speak Spanish or not. I can't recall that time if they translated, but knowing me, I probably just read it verbatim.
Okay, so then how do you?
I would have to reference back to my report, but we can't translate. We can't translate. From what I understood, you can't translate implied consent. It has to be read as is.
Understood. How did you receive consent then? Or how did you receive consent then?
She stated yes.
In English?
Yes.
Oh, okay. All right. Well, then no further questions.
All right, cross-examination.
Yes, Your Honor. Good morning, Officer Timmett. Is that Investigator Timmett, is that how you pronounce your last name?
Yes.
Good morning. So you're Officer Timmett, correct?
Say again?
You're Officer Timmett?
At the time I was an officer, I'm an investigator Timmett now.
Investigator. And you're employed?
Currently employed with the DA, the Macon-Bibb District Attorney's Office.
At the time, you were employed by the Clayton County Police Department?
That is correct.
And you encountered Ms. Leyva Reese?
Yes, ma'am.
You encountered Ms. Leyva Reese on January 1st, 2023?
Yes.
You encountered Ms. Leyva Reese on January 1st, 2023 at 2:34 a.m.?
I believe it was 1:44. Yeah, is when I arrived on the scene.
Okay.
Your Honor, I'm sorry. I just saw the translator come up. She might have had an issue.
Ms. Fitzgerald.
Speed. She came up and then I don't, it's muted, so it's fine. Okay, it's
Okay.
fine.
Go ahead.
Upon your encounter, you realized she couldn't speak English, right?
That is correct.
So you contacted the language line?
Through dispatch, correct.
Okay. In your police report, you didn't include the phone number to the language line, right?
That is correct. I didn't know it. The dispatch does the phone call for you.
And you didn't ask dispatch for what the phone number was, correct?
That's correct.
For your records.
That's correct.
Okay. Also, in your police report, you didn't include the name of the translator, correct?
That's correct.
Okay. Furthermore, in your report, you didn't include the company the translator worked for, right?
That is correct.
And you needed to speak to Miss Reese.
Yes.
You wanted to investigate the car accident.
Wanted to investigate if she was a part of the car accident.
Okay. You needed a translator to help you investigate that she was a part of the car accident.
Yes. We have two women walking down the roadway, so just wanted to. It could have been anybody. So wanted to confirm that one, she was the individual who was responsible for parking the vehicle in the ditch.
Okay. The car accident led to Miss Reese's DUI arrest.
That is correct.
Having a translator was also important to communicate with Miss Reese for your DUI investigation.
Yes.
It would have been difficult to conduct your DUI investigation without a translator, correct?
That is correct.
The translator was bilingual.
That is correct.
The translator spoke English and Spanish.
Yes.
The translator provided you with proper certification for translation.
No, we're over the phone.
Just based on your report, we can agree that there isn't any information about the translator.
Yeah, there's on my part, I didn't get her information or whatever badge number, whatever the case, not badge number, but a reference number, whatever the case is. Yeah, so on my part, yes.
So to clarify, I'm sorry, go ahead. You can finish.
No, on my part, I failed to incorporate it into the report.
Okay. Looking at your report, you can't establish whether she was bilingual or a translator with the proper certification, right?
What?
She was bilingual. She was speaking
Wait,
English
hold
and
on.
Spanish.
Okay, that's a compound question.
Okay. Looking at your report, you can't establish whether the translator had the proper certification.
No,
Okay.
but I would assume well, I can't assume, but it was provided by the county, and that's who the county. That's the company that the county relies on for all our translation.
Okay. And you can't establish this from your report because, as you testified, there's no information about the translator, right?
That is correct. But I know it's
With-
recorded, so we can obtain it.
Okay. Without any information on the translator, you didn't determine that she was honest? The translator?
Well, I hope she was honest.
But the question is, without any information regarding her certification, you didn't determine that she was honest, that she was translating honestly.
I don't know how you want me to answer that. I would assume that the resources that we have as police officers, that they're vetted and they're reliable resources where we can have that back thought not even be a thought.
Okay. And you determine her reliability, the translator's reliability?
She spoke Spanish. She was engaging, and she was engaging with Miss Louise, and Miss Louise was doing exactly what I was asking her to do, and was asking all the questions. So yeah, I would say the translator was reliable.
Okay. You didn't determine that she was competent to translate?
Asked and answered.
You would agree with me that being bilingual does not make a person qualified to professionally translate, correct?
Yes, I can agree to that.
Okay. Wouldn't you agree with me that fluency in Spanish and English languages is a necessary first step to become a translator?
Ms. Tortorello, I'm gonna say
Sure.
that we are outside the scope of what this officer can testify to. You argued as to speculation on some of the questions Ms. Bing asked, but you're asking him to interpret the viability or the ability of somebody who works for a language line. And he already told you that the county uses them as a third party contractor. So he wouldn't have been involved in contracting.
I understand, Your Honor, but based on Lopez v. State, there are factors to that the courts.
The questions you're asking him aren't going to help me get to what you want, because he's not the person who's going to evaluate whether they are the person to. He just told you the interpreter engaged with Miss Ruiz, and she did what I asked her to do. He already told you that she spoke English and Spanish. That's from his own experience. So he is not able to vet whether this person was a certified interpreter based on what the contract between the county and the interpreting service is going to require.
Okay, Your Honor. Understood.
Thank you.
Okay, moving on to the next question, Investigator Timmett. You alleged in your police report that my client admitted to being the driver of the vehicle, correct?
That is correct.
Specifically, you stated physical control.
Mm-hmm.
You have to say yes or no.
Yes.
Physical control is a legal term?
Well, physical control, meaning she was behind the wheel, driving and maneuvering the vehicle.
But is physical control a legal term?
Objection. I would say she's asking him to speculate. He's not an attorney. How would he know that?
Sustained.
And Your Honor, he's a police officer, so he does use that, but okay. Physical control is a legal term primarily in DUI cases, right?
Based on my knowledge.
I'm sorry,
yes.
Objection. It's the same question.
It is, but he's answered it. Go on.
It is not language typically used by a layperson, right?
Again, it's the same question.
Miss Tortorello, you don't know how to take an answer and move on. You've asked the same question about 4 times. I've overruled the question. He answered the question, and you're still asking the same question.
And Your Honor, just for the record,
you keep asking him whether it's a legal term of art, but actually, if you're going to parse language, physical control just means that you have control of something physically, but we do use it as a legal term of art also, so it can be either.
Okay.
So you're asking him whether she drove the car or whether she was in physical control of the car. I don't know what the clear difference is here.
My client wouldn't have said verbatim that she was in physical control of the vehicle, correct?
Ask him that question.
Excuse me, Your Honor?
Ask that question. If you want to know whether she said she drove the car or was in physical control of the car, ask him that question. You keep asking the legal import of the terms. Ask him what she said.
And I'm sorry, Your Honor, do you want me to ask the question again, or can I continue?
Continue.
Okay. So my client wouldn't have said verbatim that she was in physical control of the vehicle, right?
No, she said that from what I can recall, she was driving and she parked the vehicle in the ditch and decided to walk.
So you didn't quote exactly what she said in your report, right?
I just gave a rundown of what she said to the best of my knowledge, best of my abilities.
Regarding your report, officer, your report states that my client said she was in physical control. You just testified that that's not what my client would have said.
Well, I guess you can say that I fine-tuned it, meaning when I mean fine-tuned, meaning that used a different vocabulary. I guess I enhanced the vocabulary, but all in all, she stated that yes, she did. She was in physical control, meaning that she was driving the vehicle. That's what I meant when I meant physical control, that she was driving the vehicle.
Okay, so you're telling me that you remember what she said to you about 3 years ago without any video?
Your Honor, I'm sorry. He did not say that he knew exactly what she said from 3 years ago. He's obviously paraphrasing.
Let me ask the question, because y'all are bogging me down and we got a whole other calendar. All right, Officer Timmett, when you wrote your report, were you quoting her or were you summarizing what happened during your investigation?
Summarizing.
All right. Did you make any attempt to use exact quotes from the interpreter or from the defendant?
As best as I could, Your Honor.
Meaning that you quoted her exactly?
No, not quoted. Just summarize the whole transaction because I didn't have, it's Spanish speaking and I'm trying to do a DUI investigation. So yeah,
All right.
I didn't transcribe it.
Okay, so Ms. Tortorello, let's move on.
Okay. You're not fluent in the Spanish language, right?
No,
And you're not fluent in Spanish, so you needed a translator, correct?
that's correct.
There's no way you could have verified the translation of your questions to Ms. Reese were accurate.
She was doing exactly what I was asking her to do when I was.
There was no way you could have verified the translation of your questions to Ms. Reese were accurate.
She was doing what I was asking her to do through the translations and asking the questions through the translator.
There's no way you could have verified the translation of your questions to Ms. Reese were accurate.
I can only speculate based on what if I'm asking for her to do something or asking her a question, she's giving me the questions that I'm asking. I'm assuming that it's reliable.
So you assume that there's reliable, but there's no way you could verify the reliability of the translation.
She's answering
This has been asked and answered several times. At this point, it's argumentative and badgering.
Sustained.
There's no way you could have verified that the translation of Ms. Reese's statements to you were accurate?
Same question, same objection.
This is different because it's asking about the translator's questions to the officer, not the translator's questions to Ms. Reese.
It's asking about verifiability.
But a different question.
Tortorello, he answered it in the way that he could, which was she did what she asked her to do through the interpreter. I don't like, what do you want and what else do you want?
All right. Moving on, Your Honor, to the next question. There is no way you could have verified the translator didn't substantially deviate from your statements or questions directed at my client,
I don't speak Spanish, so I can't tell you that.
including questions regarding whether she would agree to field sobriety testing,
I don't speak Spanish, so I couldn't tell you that, ma'am.
the implied consent reading,
I don't speak Spanish. I don't know. I don't know what you want me to tell you.
whether she would consent to a blood and breath test. Okay.
I don't speak Spanish, ma'am.
Okay. Now moving on. My client agreed to field sobriety testing, correct?
Based on the translator, yes.
Okay. And you did not find any clues in the horizontal gaze nystagmus test, right?
It's not that I didn't find any clues, it's that she wasn't following my directions and she kept gazing off. It seems like she was trying to be deceptive with the horizontal gaze nystagmus test.
Well, can you clarify? Are you saying it's not that you didn't find any clues, so you did find clues?
No, it's just that she wasn't cooperating with the test. She wasn't following my finger. I can see that she was gazing somewhere else when I was telling her, giving her instructions to follow the tip of my fingers.
So how many clues did you find?
Ma'am, I could not assess any clues because she wasn't following directions as followed.
So you didn't find any clues?
Well, your client wasn't following my finger, so yeah.
You gave Ms. Reese instructions.
I wasn't able to fairly assess because the client wasn't following directions.
Okay. And you gave Ms. Reese instructions for the HGN test?
I did.
You noticed equal tracking in both eyes, right?
Say again?
You noticed equal tracking in both eyes?
Can I reference my report, please?
Yes, you may.
Mhm.
Any objection from the state?
No.
Yes.
Okay. This means both eyes were moving smoothly?
No, that's equal tracking means both eyeballs were following the stimulus.
So, so you would agree both eyes were following the stimulus?
Mhm.
Both eyes were moving smoothly in unison?
No, not smoothly at all. I didn't say anything about smoothly. It was just following the finger.
Okay. But this suggested Ms. Reese did not have any signs of injury.
Oh, I would have to
Hold
revert
on.
back to my report.
Hold on. Miss Sonia, did you need something? You have to unmute. You got to unmute that device. Go ahead, ma'am.
Yeah, but the screen is off and I'm trying to follow listening and reading and the screen is off, so I cannot even read.
Okay, did the big screen go off?
No, the big screen didn't go off, so I'm gonna stand in front of the big screen.
Oh, Mr. Lynch, if you could move Miss Sonia and Miss Ruiz's chairs up so they can see the big screen better, I'd appreciate that.
No.
Because I highlighted Mr. Investigator Timot. I'm sure I didn't say that right. I'm so sorry.
That's all.
I get it right. but I highlighted him so that it would be big on the screen. Is that correct, Mr. Lynch?
I believe that that's what I'm seeing, Judge.
Okay, so, and as long as Ms. Fitzgerald and Mr. Weiss are comfortable, let me know when they're settled.
Okay, Judge, I think they're good.
All right, thank you. All right, you may continue.
All right, Officer Timmett, so equal tracking, when you observe equal tracking, it suggests that Ms. Reese did not have any signs of injury.
Equal tracking, that would be, that would be one of the medical qualifiers.
Okay. This suggested Ms. Reese did not have any signs of injury or a neurological issue.
For better words, pretty much equal tracking is just to make sure, that they don't have any type of head injuries or, I'm sorry, head injuries that would impair the eyes. Because again, if you get hit with, let's say you get some type of concussion, you can. Give me 1 sec. I'm sorry. Long story short, yeah, it's a medical qualifier that just to make sure that she's able to. It's been a while since I've done DUI, so I apologize.
It's okay. So you proceeded with the first two passes.
Yes,
And you checked your eyes twice.
that's correct.
You checked your eyes twice and observed Ms. Reese using her head to follow the stimulus.
That is correct.
You reiterated the instruction to Ms. Reese, right?
That is correct.
You reiterated the instructions and restarted the test.
That is correct.
You observed Ms. Reese gaze off and not follow the stimulus.
That is correct.
She failed to follow your directions.
That is correct.
Because she failed to follow your directions, you couldn't assess any clues.
That is correct.
You found 0 out of 6 clues.
No, I couldn't assess anything. I want to say 0 out of 6.
What clues did you find?
There was no clue found because she wasn't able to follow the directions as explained, as I stated.
Okay. You had to repeat the instructions to her twice, correct?
That is correct.
She wasn't following your instructions, right?
Say again, ma'am?
She wasn't following your instructions.
That's correct. She was gazing off.
She wasn't following your instructions because she did not understand them.
No, she understand them. They told her to follow the tip of my finger. She would follow it, but then she would gaze off. She wouldn't be staring at my finger.
And you used a translator for this test?
I did. Yes, ma'am.
Okay. The vehicle accident happened on 6299 West Fayetteville Road, correct?
I believe so, yes.
The vehicle was a 1999 Chevrolet Astro van.
I believe so.
And the 1999 Chevrolet Astro van was stuck in a ditch.
That is correct.
The 1999 Chevrolet Astro van was stuck in a ditch near the residence of 6299 West Fayetteville Road.
I believe so.
Okay, you just asked that same question 3 different ways. You verified the address, then you said the van was stuck in a ditch, then you went back to the address. What's the point, Ms. Tortorello? Get to the stuff that matters to me.
Let me get to the point, please, Your Honor.
Okay, but stop asking the same question 3 different ways. These are simple questions. These are not boxer in questions. If the address is the address, the van, we've already heard 8 times that the van was stuck in a ditch. Either was parked in a ditch or was stuck in a ditch. So let's get past the stuff that doesn't matter. I've already heard that. It's already been established.
Yes. While at the scene, you learned Clayton County Fire and Emergency Services observed 2 women.
That is correct.
They observed 2 women walking on the side of the road.
That is correct.
The women were walking on the side of the road, therefore you didn't observe them inside the vehicle.
No, I didn't observe him inside the vehicle.
You did observe blood on the driver's side front door handle.
That is correct.
You did not observe Miss Reese in physical control of the vehicle upon arrival, right?
That is correct.
You did not notate in your report that Miss Reese was bleeding, correct?
I don't believe so.
Do you need a moment to refresh your recollection?
Please.
Well, what's the question?
You
Because
did
you
not
said he
notate
didn't notate in his report. So he said, no, I don't believe so. He's answered that question. So there's nothing to reflect on. If the next question is, was she bleeding? That's a different question. Because he answered the question you asked. You didn't notate that she was bleeding. He said, no, I don't think so.
Yeah, I just asking for him to refresh his recollection, Your Honor. It wasn't a straight yes or no. It's okay. While speaking to Miss Reese, you detected an odor of alcoholic beverage emitting from her person,
Yes.
and her eyes were bloodshot and glassy.
Yes.
She admitted to driving the vehicle.
Yes.
She admitted to driving to drinking one Bud Light beer.
Yes.
You used a translator to get her admissions, right?
Yes.
You didn't speak to the second woman, correct?
I did speak to the second woman.
Can you please indicate in what part of it says it in on your report?
It's not on my report. I don't believe it. I wrote it on my report.
So you were able to administer the walk and turn test on Miss Reese.
Yes, ma'am.
In your report summary, you mentioned you found 3 out of 8 clues, correct?
That is correct.
And you were trained to administer field sobriety tests, correct?
That is correct.
And you are familiar with the 8 clues of a walk and turn test, correct?
That is correct.
The first clue is person cannot keep balance, correct?
You said person cannot keep balance?
Mm-hmm.
Unable to maintain balance. You mind if I write the acronym?
Sure. Go ahead. And please don't read from your report. You can refresh your recollection, but when you're done, just look up.
Okay. It's U.S. shorts, unable to maintain balance.
You can read silently from your report.
Okay. Well, go ahead.
So go ahead.
Yeah, the first question is it's unable to maintain balance.
Okay. This happens when the person's feet break away from the heel to toe stance, right?
That is correct.
The second clue is when a person starts too soon.
That is correct.
And this is when the subject starts walking before they are told to do so.
That is correct.
And the third clue is when a person stops while walking.
That is correct.
The fourth is when your toes do not touch heel to toe.
That is correct.
The fifth is when a person steps offline.
1, 2, 3, 4, 5. Yep, that is correct.
The sixth clue is when a person uses their arms for balance.
Raises their arms, yes. Mm-hmm.
The seventh is improper turn.
That is correct.
And the eighth clue is incorrect number of steps, right?
That is correct.
You are only supposed to count a clue once in your analysis, right?
That is correct.
So if they do an incorrect number of steps, for example, that is 1 out of 8 clues, right?
That is correct.
And if that same person takes an improper turn, that is 2 out of 8 clues, right?
That is correct.
Because there are 8 clues, I'm sorry, because you only have 8 solid clues, you only have 8 solid clues to go by, right? For your walk and turn analysis.
Correct.
Okay. Your police report under the walk and turn section, which is page 6 of your report, only lists 6 clues. Isn't that right?
6 clues?
Yes.
Can I go back and take a look at it?
Yes,
Okay.
you can refresh your recollection. It's actually page 3, officer.
You said page 3?
Yes, it's where your walk and turn section. My apologies.
No, it should be page 4.
Officer, if you don't mind, I'm going to share my screen
Okay,
for
I've read it. Go ahead.
his report. Okay. So did you look under the walk and turn section of your report? It's not your summary, it's the section.
The section, okay.
It's page 3, I believe.
Okay, I see it.
Okay. So it only lists 6 clues, right?
Yep,
Okay. And you reported that my client took an improper turn in the first 9 steps.
I believe so, yes.
Okay. You also reported that my client made an incorrect number of steps in the first 9 steps.
That is correct.
So she did 8 steps, correct?
Based on the report, yes.
Moreover, you listed the same clue of incorrect number of steps on the second 9 steps, right?
Yes.
Okay. So you counted incorrect number of steps as 2 separate clues?
No, it's 1.
Okay. So in reality, it should be 2 out of 8 clues per your observation, right?
No, it's 3 out of 8 clues.
Where's the third?
The third one is she wasn't able to maintain her balance in the instructional position.
And where is? Okay. Okay. Fair enough. On the one leg stand, you didn't find any clues, correct?
You said the one leg stand?
Mm-hmm.
Mind if I gaze at my
Yes,
report?
go ahead. Please read it silently, and then when you're ready, please look up.
Yes, ma'am. Okay.
Okay. So you learned that so on the one leg stand, I'm sorry, you didn't find any clues, correct?
She stated that she did the test wasn't initiated. She said that she didn't understand it.
Okay. And you use a translator to administer this test?
That is correct.
And you read her implied consent, right?
That is correct.
And this was from your green card.
That is correct.
After reading implied consent, you asked for a breath and blood sample.
That is correct.
Okay.
Well, I believe, yeah, breath and blood. No, just blood.
Okay. Officer Thimmett, you were the first responder on the scene, correct?
That is correct.
And your job is to document all the facts accurately.
That is correct.
you wrote the initial report on the night of the incident.
That is correct.
In your report, you memorialized your actions involving the investigation of this case, correct?
You said memorialize?
Yes.
Yeah.
Wrote it down.
Yes.
And you signed the report affirming it was accurate to the best of your knowledge.
That is correct.
Now, directing your attention to the section on the implied consent reading, you did write, quote, I immediately read her the Georgia implied consent notice for suspects 21 and older at 3:19 hour. I asked the said offender for a breath and blood sample, and she consented to have her blood drawn in a preliminary breath test. Those were your statements on the report, weren't they?
Oh, that is correct.
But today you testify you didn't ask for a breath and blood sample.
I forgot. It's been a while.
Okay.
I should have read it on my report. That's my fault.
Okay. Would you agree with me that at the end of the implied consent statement, it instructs to designate a test, correct?
Yes.
Test being understood as singular, right?
No, it can be, you can designate all three if you want to, or you just got to read it 3 times. You got to read it 3 times and ask for each one has to be either a blood or urine or a breath.
So are you saying you can ask for multiple tests?
Yes.
Okay. And you asked her this after reading implied consent, right?
Yes.
Wouldn't you agree with me that asking for 2 tests would be confusing to someone?
No.
Even misleading, though not intentional?
If you, in my opinion, it would be actually beneficial.
For the receiver of the question?
Again, it's just my opinion. It'll be beneficial. It double checks your work. Right? If one says one thing, the other says another thing.
Okay.
Just my opinion.
And you used a translator for implied consent?
I don't believe so. I would have read it.
Okay. Okay, nothing further from defense.
All right, redirect.
No, Your Honor, there's no redirect.
All right. All right. Is this officer being retained or may he be excused?
He may be excused.
All right. All right, officer, you may be excused. You're free to go at this time.
Thank you, Your Honor.
Okay. All right, so I closed the breakout room. Mr. Gordon should be out in a moment.
Actually, I don't think that's necessary. I don't need to use Mr. Gordon. It's fine.
All right, well, let me let him know. Let's see. Because he's in the breakout room. As soon as he comes out, then you can excuse him. He'll be out in a
Okay.
minute.
I let my investigator know to get in touch with him if that's okay with the court.
Okay, yeah, that works.
Okay.
All right. So argument. I'm sorry.
Yes.
First, is there anything from the defense with respect to did you wish to present argument or testimony? I mean, to present testimony or evidence?
No witnesses or evidence, Your Honor.
Okay. All right. So I'll hear argument at this time.
Yes, Your Honor. As far as the confrontation clause, this case presents several issues for the defense, and one of those issues deals with the Sixth Amendment right to confrontation, also known as the confrontation clause. The confrontation clause provides that where testimonial statements are at issue, the only indicium or reliability sufficient to satisfy constitutional demands is the one the Constitution actually prescribes: confrontation. See Crawford versus Washington 541, US 36, 2004. Furthermore, Your Honor, case law provides that defense has the right to inquire into the translator's honesty and competency in rendering a translation. This is in Hernandez versus State 291, Georgia App 562, 2008. Though the translation itself would defeat hearsay because of the language conduit rule, prosecution must still provide proper assurances that the translator was reliable. And this is in Lopez versus State 281, Georgia App 623, 2006. To elaborate on that, this includes providing defense with the opportunity to question the translator himself in order to avoid a confrontation clause violation. This is Ursulita versus State 307, Georgia App 735, 2011. Here, Your Honor, prosecution has not provided any assurances to defense. Most importantly, they have not provided defense with the translator to properly cross-examine her or him to figure out whether the translator was honest and competent in the translation. Moreover, investigator Timmitt had no idea what the translator was telling my client in Spanish and could not confidently ascertain in his testimony as to whether he in fact knew what was actually being translated and whether the translation deviated from the statements and questions that he directed to my client. Investigator Timmitt did not have knowledge about the translator's full name and whether she was properly certified. Defense was not provided a transcript of the translator by the state. There is no way of assuring that the translator was honest and competent, Your Honor. Therefore, all statements made by my client, including the alleged admissions, her alleged consent to field sobriety, and the state-administered breath and blood test should not come in because it is a violation of the Confrontation Clause. As far as probable cause, Your Honor, if you suppress the statements made by my client to Investigator Timmitt because of the violation of the Confrontation Clause, you will not be able to find the officer had enough probable cause for the arrest of DUI. Investigator Timmitt did not observe Ms. Reese in physical control of the vehicle. Officer Timmitt did not include in his report that he interviewed the other woman to rule out any possibility of who the driver was. Officer Timmitt only had physical manifestations of odor of alcohol and bloodshot eyes. If her statements are suppressed, then her alleged consent to field sobriety should not be able to come in because she could not consent to something that she did not understand. Lack of her understanding is evident in the officer being unable to complete the HGN and the one-leg stand because Ms. Reese could not understand the instructions. Presence of alcohol is only evident here, and as you know, that is not enough for probable cause. In State versus D'Amato 302, Georgia App 181, 2010, the Georgia Court of Appeals states that it is well-established evidence which shows only that a defendant had alcohol in her body while driving provides insufficient probable cause to arrest for DUI. The court reasoned that impaired driving ability depends solely on the individual's response to alcohol, and because of the individual's response to alcohol varies, the presence in a defendant's body by itself does not support an inference that the defendant was an impaired driver and therefore a less safe driver.
Slow down, please. Thank you.
The D'Amato case also involved a one-car accident, and the officer smelled odor of alcohol and bloodshot eyes on Maria D'Amato, and that wasn't enough for probable cause. However, even if Your Honor finds that the statements of Ms. Reese come in and there is no violation of the Confrontation Clause, it is evident that Ms. Reese was not understanding the instructions of the field sobriety test due to the language barrier. Moreover, in the walk and turn, the officer deviated from his training and counted one clue twice given Ms. Reese 3 out of 8 clues. Anything related to the HGN and OLS should not come in, as the officer admitted that Ms. Reese was having trouble understanding instructions. By the totality of the circumstances, Your Honor, you should find that Ms. Reese lacked the capacity to give consent. This is in State versus Ortiz, 363 Georgia App, 829-2022. Therefore, we ask the court to find there was no probable cause to arrest for DUI, as there was only presence of alcohol, the HGN be suppressed, and any evidence after is fruit of the poisonous tree and should also be suppressed. Moreover, the walk and turn and the one-leg stand is inadmissible due to unfair prejudice against Ms. Reese and her lack of capacity to give consent under the totality of the circumstances. As far as the implied consent was misleading. Your Honor, as you know, case law states that the determinative issue with the implied consent notice is whether the notice given was substantially accurate as to the to permit the driver to make an informed decision as to whether to consent to testing. This is State versus Chun, 265 Georgia App, 530-2004. Here, Investigator Timmett read the implied consent notice, and following the reading, the officer asked Ms. Reese for a breath and blood sample. This is confusing and misleading, as the implied consent notice requires the officer to designate a test and not tests. Moreover, if the officer asked for a state-administered test of her blood and also asked for a portable breath test immediately after implied consent was read, it deviates from the reading and was not substantially accurate. A reasonable person would think that the implied consent notice requires a state-administered chemical test of her blood and a portable breath test. This is misleading and confusing, and the reading of the officer here is substantially inaccurate. Moreover, the ask by Investigator Timmett of my client's breath and blood sample after reading implied consent triggers Elliott versus State, 305 Georgia 179 to 2019. Based on the way it was asked after implied consent, one could infer Investigator Timmett was asking for a state-administered blood and breath test. Here, the state only withdrew blood and did not take a breath test. The court could also infer that because the breath test was not administered, Ms. Ruiz refused. Therefore, her refusal of the state-administered breath test should not come in under Elliott versus State. Moreover, the blood test should be suppressed because the implied consent warning was misleading. Nothing further.
All right, so Ms. Bing, just as before you argue, the court would make the decision that the refusal of the breath test, even because of the presence of a blood test prior to any other thing being decided, but the presence of a breath test you've already agreed to the suppression of the PBT, but the court wouldn't allow the information about a refusal of a breath test to be admitted into trial. So that decision is an easy one to make because she had already allegedly consented to a test, or there was no test at all. So it wouldn't be a refusal if both were requested.
Honor, can you please slow down, please?
Oh, I'm sorry, Miss. So the court would not allow the refusal for the breath test. So that's an easy decision to make. So the determination now is whether the implied consent was invalidated by asking for 2 tests, but on the basis of there being a breath test and a blood test, the court would not allow the refusal to be introduced in court for the breath test. Okay, or the implied refusal. All right, go ahead, Ms. Bing.
Okay. I'm going to take a page out of your book and get rid of some easy stuff first.
That sounds good.
Okay. Number one, the green card. He said that he had read from the green card, and you can take judicial notice of the content of the green card. It does not ask for a test. It says or. his asking for the blood, and a PBT test was separate from that as opposed to an intoxilizer. He asked for the blood. That was what he was driving at. I don't think that that's misleading at all. I think a regular layperson would not be misled by that by any means. This is written in lay terms. Secondly, PC, probable cause. I've mentioned this earlier, but Frederick v. State, 270, Georgia App 397, year 2004. This is a quote. The defendant admitted that he had been drinking. The officers smelled a strong odor of alcohol on the defendant's person and observed that the defendant's eyes were glassy. We held that the arresting officer had probable cause to arrest for less safe DUI, end quote. State v. Sledge, 264. Am I going too fast I forgot about the translator.
Yeah.
Again. I'm so sorry. Okay, Mr. Lynch.
I think just slow down a little
Sledge.
bit.
Okay, yes. State v. Sledge, 264, Georgia App 612, 2003. Quote, the Court of Appeals of Georgia has found that even in the absence of field sobriety tests, an officer's observation that a suspect has bloodshot, watery eyes, and exudes an odor of alcohol is sufficient to show probable cause to arrest the suspect for driving under the influence. Here, we have more than just the presence of alcohol and bloodshot eyes. We have the admission of drinking. And we have the admission of drinking. I'm not arguing for the PBT to come in, but on the scene, he also had a PBT that showed a positive screening. So he had more than enough probable cause. I think improper FSTs were an argument. This goes to the improperly done FSTs go to weight, not admissibility. And whether she was able to understand because of a language barrier or whether there was just a comprehension issue, not because of a language barrier, because there are plenty of English speakers that don't follow directions. That is also not a matter for this hearing. That is a matter, I think, for a jury to decide. Miranda, I think Ms. Tortorello said that was connected to PBT, and so that's not something to argue. It sounds like the thrust of her argument is about the confrontation clause and hearsay. I took the liberty of looking up the ones that she cited. And I think that there's confusion on the part of the defense. So for Lopez, there is some burden to show that there was no motive to mislead or distort the translation. But the court in Lopez only required that it be shown via circumstances of the case, not in court testimony, which is why the statements were admitted in that court without the translator having to testify. Additionally, additionally, the second case that defense cites in her motion is Hernandez v. State. That's 291, Georgia App 562. There were two issues in this case, and I believe defense has conflated the two. The one issue is about translation and the defendant's interrogation statements. That's at 566. The second issue was about whether a confidential informant's identity should be revealed. That confidential informant was not the translator and had nothing to do with translation at all. It was on that point that the case got remanded back to the trial court. The Hernandez court concluded on the issue of translation that the language conduit rule held and that the translator did not need to appear. The court drew that conclusion on the following bases. Number one, the defendant did not indicate in what way the translation was not reliable. Number 2, the translator showed that she had the capacity to translate in the interview, even though she wasn't certified or professionally trained to translate. It was enough that she could just demonstrate that she could speak Spanish and English. 3, she also regularly helped during the course of her work with translation issues that came up. 4, defense failed to show any motive that she would have to translate, that she would have translated incorrectly. So as a result, Hernandez court concluded that there was no hearsay violation nor a confrontation clause where the state did not produce her for court. Here, the exact same things are true. Defense has failed to identify in what way the translation was inaccurate or any motive for the language line operator to mislead or distort the translation. We heard Officer Timmett say that this is a contracted separate company, has no investment at all in the outcome of the conversation, not even connected with PD. The operator adequately demonstrated, per the testimony, that she was capable of speaking both English and Spanish. And we know that because it was translated without her being able to even see the scene that the car was parked in a ditch, where the person lived, and that was confirmed on through her driver's license, that she had had something to drink that evening. So the state would ask that the court follow the precedent in Lopez and Hernandez by adhering to the language conduit rule and dismissing defendant's claim that the interpreter is required to appear for questioning. I think that covers it.
All right. So, Ms. Bing, I fuss at you if you get it wrong, but I will tell you that I did appreciate your elucidation of the cases because that's where the court was going. I did not had you, Ms. Tortorello, told me that this was somebody who came along on the street or this was somebody's family member or somebody else who was interpreting, then I would have looked for indicia of reliability, of the ability to interpret from English to Spanish and from Spanish to English. But when you tell me it's the language line that's used all the time, it's a third-party contractor, and the whole purpose of the contract is to have reliable interpretation on the scene for use by county actors, then to me, you have to come with a stronger indication that there was a reason to distrust the interpretation through the language line, and you didn't provide that. The mere fact that there is an interpreter, if we had to provide the interpreter's testimony for every case and every language where the language line is used, or even an in-court or out-of-court interpreter, well, the whole purpose of that would clog up the system. The point is that the indicia of reliability is in the contract itself. And so you have to overcome that to state that the confrontation clause is not met because there was some indicia that the person interpreting wasn't reliable. You don't have that here. The officer had no motive to do anything different other than to follow his regulations and call the dispatch. Dispatch had no motive to call anybody but the language line. The language line interpreter had no motive to do anything but interpret. And the officer's testimony establishes that at the scene, he was able to get Ms. Ruiz to do what he asked her to do based on what he requested through the interpreter. So that part of the testimony, I'm going to have a real hard time finding that there's been a reason to suppress based on that. Now, you all have agreed that the PBT test doesn't come in. Well, the number for the PB test wouldn't come in anyway. The fact that it exists could have come in, but there's an agreement by the state that that doesn't come in. But you've heard where the court is leaning on this because I don't think you've met the burden of establishing that there's any reason to distrust the reliability of the interpreter in this case. And I use interpreter because, as I was told at the beginning of my legal career, that translators, and I know people use them interchangeably, but translators translate the written word from one language to another. Interpreters translate the spoken word. And so that's why I use the term interpreter. But we'll get an order out to you, so you all can be guided by my comments in how you move forward. Okay. All right. So on the 11 o'clock calendar, we have a gentleman who's here from one of the state prisons, Johnson State, and they've made him available. And I know that we have taken a lot of time, but he's still on. So on the case 2023 CR 00415, Willie Frank Johnson. Mr. Johnson has a driving on a suspended or revoked license, no license, and no insurance. And he's been produced for this. So do we have anything on Mr. Johnson's case?
Yes, actually, I think we issued a null or drafted a null pros last week. And the bench warrant has, pardon me?
I'm sorry, I was just wondering if I signed it because I signed a lot of stuff, but I can't always remember the names of the people.
I don't know, Ms. Arnold. I asked Ms. Arnold to draft it. I'm not sure if she sent it yet, but it's always in good hands with Ms. Arnold.
Your Honor, you've already signed it and it's been filed and the bench warrant has been set aside.
Thank you. I knew you had, Miss Arnold, because I know she sent me stuff. I didn't know if it was this particular thing. Mr. Johnson, thank you for your patience. Thank you for the patience of those of you who made Mr. Johnson's presence available. And at this time, Mr. Johnson, I verified that your case has been null prossed and the bench warrant has been set aside. I know that this is necessary for you to move to the next phase. And so I wish you well in that. Remember that you don't want to get back to where you were. You want to enjoy the new phase that you'll be moving into, okay? All right. So take care, Mr. Johnson, and thank you all for making him available. You all are free to go at this time.
Thank you.
Thank you, sir. All right. So on the 11 o'clock, hold on just 1 second before I call the 11 o'clock calendar.
Process right now.
right, ladies and gentlemen, so the first case on the calendar is Javon Eric Barnett for the 11 o'clock calendar. And this is Miss Watson Cafe's client. I know that we have put this on we put this out for a ways, and she's actually there. The case is actually on a February 2nd motions calendar.
Okay, this is going to be null prost. Ms. Arnold wants me to let you know that you did not sign this one yet.
Okay. All right. So I will sign it as soon as it comes across. And she probably already sent it. I see.
Yeah, she sent it to you.
Yeah, I see a bunch of things that I need to sign this morning. So, Miss Watson Cafe.
Yes, Your Honor.
Okay, so the case is being null pros. Thank you. I know this case started out a little rough for you, but I appreciate your professionalism and for making this happen and sticking with it.
Thank you, Your Honor.
All right, take care.
Thank you.
And Judge, I know that the only case on the calendar involving Mr. Barnett was Ms. Watson Cafe's case. He does have several other cases, and I have been in communication with him, also his mother, and have got some documentation about the steps that he has taken to get himself in a better place. So I think it's turning into somewhat of more of a positive, at least than where we started. And so I'm happy to talk to Ms. Bing. I hope that we will work out an agreement to resolve the rest of the cases. I know there's no agreement yet, but I just wanted to let the court know that I am working on that and aware that it's our task to get everything else wrapped up for the court in a timely manner.
Yeah, I'm glad because you all were working together, thank goodness, to kind of get us in a posture where he could be in a better place. And so it'll be on the February 2nd calendar. But if y'all work something out prior to that, let me know, and then we'll see what we can do about that.
Okay. Thank you, Judge.
All right. Then Fatima, I have Fatima Rua McEachin.
Yes, Your Honor, she's in the courtroom, per my understanding. We're going to move forward with the motion.
All right.
Your Honor, just the victim's here and wants to make a statement. Just
okay.
So you know. Okay.
All right. So we'll have a hearing in a moment. The next case is Kendall Lanier Parker.
Judge, that's a defense motion for immunity. We are going to go forward on that.
Okay.
State's null prosing.
All right. So the state is going to null pros the Parker case, and anyone associated with that case. If you don't have anything else before the court, you're free to go at this time. All right. Shirley Downing Polk.
Present in court. Ms. Polk. Ms. Polk is present in court, Judge.
All right. So this is a motion to modify sentence. All right. We'll talk to Ms. Polk in a second. And then Alasia Lynn Real or Real. Lister Holton.
Yes, Your Honor, she's on the line. So I've filed a notice to withdraw from the motion to suppress. But she has expressed that she would like to hire private counsel.
Okay.
And she is aware that she's on the February 2nd trial calendar, but she's requesting if she could be reset to the March trial calendar.
Okay, Ms. Real. Ms. Real?
Yes, ma'am.
2022 case. You're already on a trial calendar. Why should I delay this case, ma'am?
I feel as if I really don't want to badmouth anyone, but for the sake of, my future, I think it's best if I go with someone else.
Okay, so listen, I could deny the motion, but I'm gonna give you until March 1st. But to the March trial calendar, you'll get notice. But here's the thing. No attorney likes to have a case that's been hanging around since 2022. And then you tell them a month before trial or 3 weeks before trial, hey, I have this case. Can you take this case? And it's on the March trial calendar. I'm not guaranteeing you a continuance. And that's the first thing they're going to ask for.
I've already spoken to who I'm going with. I have a payment arrangement with
Okay, you don't have to
Hack and
take.
Maloof.
Okay, so here's the thing. They need to do an entry of appearance as soon as possible. And that does several things. One, it lets me know who you're going with so I can release Ms. Tortorello from the case. Number two, it lets me know who is going to be responsible to show up in court the next time you have a court hearing. And number three, until they're in the case, they're not going to get discovery from this case. And so they have to do an entry of appearance in order to get the discovery that's already been given to Ms. Tortorello. She'll turn that over to them, and also to get any additional discovery from the state.
Yes, ma'am. I understand.
All right. So I'll put you on the March calendar, but please be mindful that if somebody comes in here and they're asking for additional time, that might not be given.
I understand. I
All right.
thank you for the opportunity.
All right. You're free to go at this time.
All right. Thank you.
All right. So I have show below you, Mr. Laguda, a motion for immunity, but I feel like we did something on this case. What did we do?
Yes, we did, Your Honor. That's going to be a plea, and I think that he asked to be excused for today.
Okay, so he wants to take the plea on February 2nd?
Yes, I believe so.
All right, so that's fine. Dana Lauren Talley. This case was closed. Okay, so they're not here on that motion. Tanya Mache Walker.
Yes, I'm here.
Judge, she's
All right.
present. The defense is ready to go forward.
All right. So this is going to be a motion to suppress. What else is on the motion to suppress? Because it's motion in limine on what issue?
Judge, we're arguing that the evidence, the blood should be suppressed as a result of an illegal stop, unlawful detention. Just a pretty basic argument there.
Okay. All right. Brianna Laura Williams.
Your Honor, that will be a plea today.
All right. And then the last case.
You got to send me the money for the dog.
All right. Nina Black, I'm going to need you to mute your device.
I'm on mute.
Okay. Yeah, mute.
I'm sorry.
Try to conduct business. Kioshe Hyman. Does anybody recognize that name? Because I don't have it on my calendar, unless it's on the 1 o'clock calendar. And ladies and gentlemen,
no, I believe she's a victim on a case.
Okay. All right. So at 1 o'clock, I'll have 2 separate calendars, ladies and gentlemen. We'll call those calendars sometime after the 1 o'clock calendar, but it's going to be a minute because we have hearings to do. Please make sure you have your first and last name on the screen if you are present for a hearing. First and last name on the screen. That helps me. And second thing is mute your device so I don't hear you while we are doing this. The last case on the motions calendar is Jones, Levon Williams Jones.
He's present in the courtroom, Judge. I'm sorry.
All right. He's asking to reopen and modify sentence. All right. What was the term of court? Because I might not be able to do this.
Which case are you on? I'm so sorry.
The last one on the calendar.
Williams?
Yeah.
I mean, it looks like it was closed in August of 2024, Judge, not to jump in where I'm not needed, but.
Yeah, I can't reopen that case. Are they here, Williams?
Come forward, whoever.
Come on up. Okay, so Mr. Heyman, it's my understanding that your attorney requested a reset to the February 2nd case, so you can be excused.
Right in front of the screen.
All right, Mr. Williams.
Yeah.
Mr. Williams.
Hello.
So you're asking to have a case that was resolved in 2024 reopened so you can modify your sentence.
Yeah, so I can keep my job. I work for FedEx.
Okay, so what we'll do is we'll look at it. If the state has any objections, you all can state your objections, and then we'll see if it is possible legally to do that. In cases, certain cases when a sentence has been pronounced, the court loses the ability to do anything with the case after a certain passage of time. So sometimes it's certain terms of court. Once those terms of court have a number of terms of court have passed, then I may lose the ability to do anything. And this is a traffic offense. And so generally with traffic offenses, I have to reopen or modify within a certain amount of time. And I'm pretty sure that that time has been exhausted. Okay, but we will get you an order that explains everything and the courts, whether the court can or cannot do what you're asking. All right?
Excuse me, Judge, can I ask you a question?
Yes, ma'am.
Okay, I'm Samantha. My only question with that was, being that I'm the one that actually took care of the ticket, he never actually went to the court date. I paid for the ticket prior to the court date because we wasn't gonna be here for the court date.
I get that, but there's a period of time, even after you pay for it, where you can come into court and ask to have your sentence modified, or you can ask to have the whole case heard. And then if you win your case or it's dismissed or anything, you'll get that money back. If not, then whatever the court orders you to pay, if you're due a refund, they'll give you that back. If you have to pay a little bit more, you'll just pay that whatever is extra. The problem is that when you do it online or you just pay it, it's considered an admission of guilt. And so it goes in as a guilty. What I'm saying to you is it is not that that this is not a process that doesn't happen, but there is a time limit on when it can happen. And there's a certain number of terms of court that I have to observe before I lose the ability to reopen it. Like I just won't legally be able to do it.
Okay, now being that we're not looking for any type of refund, anything like that.
Ma'am, I'm telling you, the money part would be easy, but I will lose jurisdiction over the offense such that I could take any action in it.
Okay.
And that's as clearly as I can explain it to you. Had you come in within a month or two of what happened, or you know, because people come in all the time and say,
"Doctors notified of the situation, so we didn't."
I got you. I get that, but this is all I can tell you is that we will look at it. But what I'm telling you is, I really believe off the top of my head that we have gone beyond the number of terms of court in which I can exercise any jurisdiction.
Okay, thank you.
Judges, judicial power is not unlimited. We do have structure and limits on what we can and can't do.
Okay, thank you.
You're welcome. If we can do it, we'll do it. If not, because I mean, it's not gonna make a difference to me. We can do it, we'll do it. I believe in saving people's jobs, but if I'm unable to do it, I will explain that in the order.
Okay.
All right, thank you.
Have a good one.
All right, so we have a plea. Let's go ahead and take the plea on Shabaloju.
I'm sorry, I think that was gonna go on
It's on the February. I'm sorry, yeah. Ms. Tortorello has a plea on Williams, Brianna.
Yes, is she in the court? Is she in the courtroom?
Brianna Williams? I don't see her online.
Brianna Williams is in the courtroom. Are y'all ready to go forward, or do you need to speak to Ms. Williams prior, Ms. Tortorello?
No, we already spoke unless she needs to speak to me.
Okay, come forward, Ms.
All right, Ms. Williams, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right, you can put your hand down. You're before the court on 2022 CR 01892 for no license, count 1, leaving the scene, count 2, DUI, count 3. You're represented by attorney MJ Tortorello with the law firm of Lister, Holton, and Dennis. Ms. Tortorello, what is your client plea to the offenses before the court?
Yes, Your Honor. For count one, no license, that will be no prost, from my understanding. Count two, leaving the scene, that will be a guilty plea. And count three, DUI, that's going to be DUI reduced to reckless.
Okay,
Reckless driving, and that would be a guilty.
has the accusation been amended?
Your Honor. Yes,
Ms.
Your Honor.
Bean?
Yes,
Oh,
Your Honor.
okay. I'm sorry, I missed the yes part. All right, so, and it's gonna be count three, or did you add a count?
I did count.
Okay, so it'll be count
yeah.
four?
Sorry, there are 6 counts on here.
Ooh.
Count one was no or none or class violation. Count two was leaving the scene. Count three was driving under the influence. Count four was obstructing an officer. 5 was
That
leaving
was
the
for
scene.
Yeah,
that was
those
for
should be
Mr.
for a
Yarborough.
co-defendant.
Yeah.
Yeah,
Count four and
four.
five is
Okay, I'm so sorry. Then, yes, okay. It on the paper, it's all convoluted, but her actual accusation is amended. Yes. Brianna
Thank you.
Williams, reckless driving. Yes. So sorry
So
about that.
I'm just asking, sometimes y'all will add a count, or you
So it's
will.
count 4.
Okay, so it'll be count 4 for her. Okay. All right. So, and that'll be a guilty, and DUI will be no prost. Okay. So by entering a plea of guilty to counts 2 and 4 as amended, the accusation reckless will be count 4, and count 1 no license, and count 3 DUI will be no prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things? You got to speak up a little bit for me.
Yes, ma'am.
All right. Factual basis and recommendation, please.
Yes. On January 8th, 2021, Miss Williams was driving a car. She hit parked cars, several parked cars, and she was driving under some influence. The state's recommendation is for count 1, null pros, count 2, 12 months to serve 3 days, credit for time served, $300 fine, 40 hours community service, substance abuse evaluation and treatment, risk reduction course, no drugs or alcohol random testing. Count 3 is null prost, and count 4, reckless driving, is the same, but it's going to be concurrent with count 2. So the exact same recommendation, but concurrent with count 2.
Okay. All right. Ms. Tortorello, anything on behalf of your client?
Yes, I was hoping that we could agree that count 4 would just say 12 months of probation concurrent to count 2. My fear is that maybe probation may have mistaken that as double of the requirements that she has to make.
Well, probation is pretty savvy with these, but if you want just 12 months concurrent, that's fine.
Thank you, Your Honor.
No objection here.
All right.
Thank you.
So count 2, 12 months to serve 3 days, credit for time served. The balance will be probated for you to pay a fine in the amount of $300. The fine with the surcharges, the total is going to be $444. 40 hours of community service. You'll take a substance abuse evaluation and any treatment that might be ordered. You're to take a risk reduction course, to have no alcohol or illicit drugs during the course of your probation. And you're subject to random screens for alcohol and drugs. That means no alcohol, no marijuana, no edibles, no cocaine, no nothing, because people have been testing for everything nowadays. Count 3 will be null prost, and count 4 will run concurrent. It'll be 12 months to serve concurrent on probation with count 2. All right, so Miss Williams, let me just be honest. You've been to court enough times. You've heard me fuss at people. This was an old case. I do not reduce DUI sentences. You serve out the whole thing. But what I say to you is what you're required to do as quickly as possible. If you have any problems getting through the special conditions of this sentence, please talk to your probation officers because they will go to bat for you. If you're a good probation candidate, they will go to bat for you and they will help you successfully complete your requirements. Okay. The quickest way to get this behind you is to make sure you show up for your probation reports because that's the quickest way to get arrested. If you show up for your probation reports, you won't have any problems with that from that perspective. Do what you're supposed to do. If you're having trouble finding programs, ask questions. Okay. What y'all children say, closed mouth don't get fed. So if you don't ask questions, nobody's going to know you need help and they're not going to be able to help you successfully complete. All right. Do you have any questions for me? All right. So you're going to exit the courtroom. When you exit the courtroom, you're going to go to your right. You're going to go in courtroom 305. When you get through the first set of double doors, Miss James will be in there. If she's meeting with somebody, she's just going to ask you to wait in the hallway until she's ready to have you.
Yeah, sure. It just come back. I know.
Hello. Hello. Oh boy. Okay. Who's not muted? Everybody on here should be muted except for the person I'm talking to.
Miss Davis is not muted.
Oh, yeah. Thank you. All right. So, Miss Williams, so yeah, you're going to go into the next courtroom over to the right. Miss James is going to do your intake. She's our expert. Ask her any questions that are specific to what is going on in your life right now that you might need to have figured out before you start probation. Okay.
Yes.
All right. So you're free to go at this time, ma'am.
Thank you.
All righty. So we have 2 hearings or 3 hearings. We have an immunity hearing and suppression hearing. I'm ready to go whenever you're.
I don't think we have an immunity hearing. I think that was a plea.
Correct. There's a bond modification hearing and a DUI hearing, Judge. I believe Miss McKeechin and Miss Walker are the 2 remaining that I heard, Judge, that I heard.
Okay, so on the bond modification and the immunity, let's hear the bond modification real quick. Y'all couldn't come to a consent on that?
Second. Was that McKeechin?
Yeah.
McKeehan, yes.
McKeon. Okay.
Oh, McKeon, I'm so sorry. Actually, so my understanding is that they want the modification to include that she can have contact and to come home. Our victim says that they don't want that. I did express that to Ms. Tortorello. Ms. Tortorello said that she still wants to move forward. Our victim has safety concerns and does not want contact. So I'm not really sure. Yes, I'm not.
Oh, I'm sorry.
Yes, so I'm not really sure on what grounds she's going forward.
How would we go forward with the victim not wanting to have contact? Explained.
I've already expressed this to my client, Your Honor, but we just want a chance to be heard briefly on this.
Hey, Ms. Tortorello, we everybody wants a chance to be heard, but if there's nothing you can argue to me if a victim doesn't want contact.
Okay, so obviously we're not gonna have a formal hearing. So basically, Your Honor, my client is paying for the mortgage right now, that the house that he's living at. They're both on the title. Mr. McKeon has been contacting my client as of recently, nonstop about the house, about the insurance, about some of the contact has been about their marriage. I have copies of that. That's why I would like to have a formal hearing to show that he in fact does not really has any safety concerns. She's been living in a homeless shelter for domestic violence survivors, one out of Atlanta, and then excuse me, Securus House.
Let me ask a couple of questions. Mr. McKeon?
Yes, ma'am.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So you and the defendant are married.
Yes, ma'am.
Y'all are living in the same house.
Yes, ma'am.
Both of your names are on the title to the house.
Yes, ma'am.
Have you had contact with her regarding the house?
It's a few things that I don't want nobody getting in trouble. The reason I contacted her and not nobody else, but I don't have a problem with her. If she can calm down, I don't mind her coming home.
Okay,
As long as
so
she can conduct herself properly.
well, now I can't tell you she gonna conduct herself properly. That's not what I do. I
Yes, ma'am.
ask you the question about whether you have any fears or concerns for your safety. If you do, that's one thing. If you don't, that's another thing. But
No, ma'am, I don't.
okay, so if this is about the property, though, here's the issue. If this is going to be a source of contention because y'all fighting over this property or having issues about the property, me giving her access to the property is just going to be another way for somebody, and I'm not necessarily saying her, for somebody to end up back in court or end up arrested. So that's my concern.
That's my concern too, ma'am. Because like I say, I'm peaceful. I don't want no problem. If she can come home peaceful, then I'm fine with that. Then, like they said,
How long y'all been
ma'am,
married?
9 years.
Where's Miss McKeon? Miss McKeon. I'm sorry.
Ms. McKeon's in the courtroom, Your Honor.
Come on up, Miss McKeon.
Your Honor, while that's
Hold on.
Okay.
Hold on. Miss McKeon, is it your intention to still be married to Mr. McKeon, or is there a break in the marriage?
There's a break. We're going through a divorce.
Okay, so Mr. McKeon, you're aware you're going through a divorce?
Yes, ma'am. I understand all that, and like I say, I'm fine with that. Being fine with it.
Okay.
I'm not the one that's acting wild and what's the name. I mean,
Okay,
I'm fine with
look,
that. We
now,
just have to make it work in the same house. I
here's
don't have a problem with it.
That's the issue that I'm having, because if y'all are gonna cohabitate, both of y'all need to be under the impression that any actions you take that are, like, if you're going through a divorce, you will get what is called a standing order. The standing order will direct your contact towards each other. If you pay attention to the standing order, you should not have any issues. It is difficult to divorce while you are in the same house, but I understand that sometimes finances and circumstances require that. What I'm going to do is I will allow the bond to be modified to allow Miss McKeon to come back with no violent or harassing conduct. But please understand, Mr. McKeon, that does not mean that you also cannot come under court scrutiny if your actions would invite an arrest or a violation of the law. Do you understand that?
Yes, ma'am.
Okay. Ms. McKeon, is it your desire to have contact of a no violent or harassing nature?
Yes, ma'am.
Okay.
Your
All
Honor,
right.
I'm
Yes.
sorry, Your Honor, I'm so sorry. I just feel like I need to at least put this in your
Yes,
purview. Mr. McKeon has talked to Ms. Hemphill, and my understanding is that what he said, and this is a quote, that if she came back, somebody would go to jail. And that to me is obviously very different from what you're hearing today, but I'm not sure why that's changing. I'm not sure if what he's saying today is sustainable, but I want the court to know that that's where we were just a few days ago.
I don't doubt that. And like I said, a lot of times it's because of the finances and the circumstances.
Sure.
It's not that, ma'am.
I'm sorry?
I mean, I just heard maybe that's a lawyer, whoever said that she's paying the mortgage for a house I'm staying in. I'm paying the mortgage too. I pay the mortgage and she pay the mortgage. Sometimes it's 1 month, it's another month. So I'm paying bills. Then, like I say, I don't have a problem with her, but much of the stuff she did, she would be in a lot of trouble, and I don't want nobody in trouble. So I just don't mention. That's why I just hope you could explain to her again what the standing order is.
Well,
we have problems with that.
So yeah, this is giving me some concern because Ms. McKeon, I understand the financial and cultural, I mean, not cultural, contact issues that you're out of doors, you're trying to find a place to live. How big is this house?
Almost 3,000 square feet.
Okay, because there's got to be some way, if y'all really want to sustain this, for y'all to be in the house and have minimal contact with each other. Now, that's hard to do when you're living in the same house. But I understand the Miss Bing's concerns. Ms. Tortorello, how does your client anticipate making this work?
My client, what she intends to do is not have any violent contact with her. She's moved on from Mr. McKeon. She just wants a place to live, Your Honor. She has autoimmune disease. As you can see, she's wearing a mask, and being in a shelter with autoimmune disease is very concerning. There's viruses and things at the shelter. And so she has tried to go to her brother's house for a minute, but they live with children and she cannot be around children. That's why she's been from shelter to shelter, Your Honor. And she's about to be let go in a couple of days from Secura's house.
Okay.
So she's going to be homeless. And it's going to be really hard at that point in time for her to move on with her life and actually keep up with the mortgage as well.
I feel like y'all are going to be back before me, because I feel like this is not sustainable. But I do understand the health requirements that Ms. McKeon has, and I understand the financial issues that you both have. But Mr. McKeon, you can't call yourself a victim and then contact her about stuff about the house. If she can't have contact with you, if you're contacting her, how do I pay this? Where does this go? What is going on with this? Then you put her in a bad position where she could face the consequences of a probation revocation. I mean, of a bond condition revocation. And you just can't put her in that position. So with that being said, I'm going to allow the bond to be modified such that Ms. McKeon will have no violent or harassing contact. The court understands that the parties will cohabitate in the marital home. They are to follow any standing order given to them by the Superior Court pursuant to the divorce. And they are to avoid any contact that would result in any violence, irritation, annoyance, or harassment.
Okay, Your Honor. She just has to, like I say, how they say I was contacting her and contacting her. She just had to stick to the standing order and to the what you saying do.
Yeah, but
As long as she's doing that, I'm fine with that. I never had a problem with none of that.
Okay, Mr. McKeon, but I get that it takes more than one person to have a marriage, and it takes more than one person to have a marriage fall apart. So just because she's the one she's under the court's direction, doesn't mean that both of y'all are blameless in this. What I want y'all to do is to follow the orders of the court so that we don't have other issues while you are divorcing, okay?
Okay, so do she need to go to anger management now, or does she have to wait till she go to court?
I don't know. Whatever the Superior Court has ordered, that's what
that's fine.
You can do.
I mean, if it get bad, ma'am, I try to get out of this. I'm not trying to be in no trouble, and a lot of this stuff that's being said is not really what happened. I mean,
haven't said
if it gets
anything.
bad, I know not you, ma'am. I'm just the other lawyer. What she was saying, all this stuff is not true. But if anything start looking crazy, I'll leave for some days or whatever. I'm not trying to get in no trouble. I'm not trying to get nobody else in no trouble.
Okay, so this is going to be modified, but you all have both been kind of put on notice of what the consequences are, okay?
Okay, so is it okay that we put cameras throughout the house to make sure it's no problem?
Ms. McKeon, do you have any problem with that?
No, ma'am. Can I say something, Your Honor?
I don't know. I don't like to have you say something when you have an attorney.
Yeah, Ms. McKeon, you have the right to remain silent. So everything here is being recorded and can be used against you. I don't have any questions. Thank you.
All right. So yeah, if you put cameras in non-personal places. I don't want to see nobody, having a camera in the bathroom. That's foolishness.
Oh,
But
yes,
if you
I
want to
know
put
that.
up
Yes, ma'am.
cameras, that's fine. I don't have a problem with that.
And one more thing, Your Honor. The house under the standing order is everything is accessible to both of us.
Okay.
Each room is accessible to both of us.
Yeah, but Mr. McKeon, don't use that as a way to harass each other. If she
I'm not gonna
establishes,
harass. I don't have a problem with her,
listen
man.
to me.
I'm
Listen
sorry.
to
I'm
me.
sorry. I'm sorry.
Listen to me, both of you. If you each establish yourself in a particular room to sleep and keep your personal items, then that is not where you freely go. Just because the house belongs to you doesn't mean that you freely go into where the person has to say. If y'all got a guest room, somebody sleeping in the guest room, somebody sleeping in the main bedroom, then maintain those boundaries, because that doesn't give you free reign to go throughout the house, to go searching for stuff, to go bothering people. That's how folk get in trouble.
Yes, ma'am.
Ms. McKeon, you understand?
Yes, ma'am.
And she knows.
All right. Okay. Listen. I'm not a
Yes.
marriage counselor and I don't do divorce. I'm just
All
trying to keep the peace until y'all can separate. So that's what I'm doing. Get me the order, Ms. Tortorello. Pass it to
Yes,
Ms.
Your Honor.
Bing so she can look at it, and then I'll sign off on it if it says what I said it should say. Okay.
Your Honor, can you go over, it says no violent harassing contact, and she's allowed to return to the home. Anything else that I need to add?
Yeah, that if they establish themselves in separate bedrooms, then the other party is not to enter that bedroom.
Okay.
Thank you.
And that will be the problem on the bedroom situation.
Y'all don't have a guest room, Mr. McKeon?
We got a guest room.
All right, then one of y'all can be in the guest room.
That's what we would need to know now, man, who's going to the guest room. I mean, I'm in the main bedroom, so if she's going in the guest room, that's fine. I just don't want that to be the first problem.
Ms. McKeon, would you go to the guest room? Would you agree to go to the guest room?
I'm going to the 4th bedroom. My mom is coming with me.
Oh, no.
Okay.
All right. That's all. This is all the marriage counseling I'm doing today. So give me the order. We're good to go. Okay, so we have a hearing on Walker.
Thank
Judge,
you, Your
before the Walker hearing, how was Tally disposed of?
Tally is closed.
Oh,
That there's no need for a hearing. The case is closed.
Understood.
No cross. All right, Walker.
Finish, Your Honor.
Yes, sir.
All
You're
right,
free
well,
to go.
thank you. All right, thank you.
Right.
Take care. All right, bye-bye. Man.
I can still hear you.
Yeah, this is.
All right, next. All right, so ladies and gentlemen who are here for the 1 o'clock calendars, I'm going to call those calendars in a minute. I have a hearing to have. So let me call the SSD calendar. And the reason I'm going to do that is because I can put you all in a breakout room with Miss Powell, and she will explain everything and tell you who is going to have a modification of their sentence. So with the SSD calendar, it means you were before the court previously. It means that you owed money to the court because you had fines and fees. You did not pay those fines and fees within the time limit that the court gave you. You are now facing an arrest warrant because of your failure to pay. The court is going to give you one last opportunity to have a modification of your sentence so that you can pay within the time that the court gives you. Please understand that if you fail to pay within the time that the court gives you, then an arrest warrant will issue, and I will see you on one of my jail calendars when you are arrested. I'm going to put you in a breakout room with my staff attorney, Ms. Powell. Ms. Powell will explain to you the modification. She'll talk to you about your particular circumstances, and she will determine whether you're going to come before the court for a grant or a denial of the modification. I'm going to call the calendar, and if you hear your name, please respond and let me know. Please keep your devices muted, because otherwise I'm hearing stuff that I shouldn't ought to hear. All right. First name on the calendar is Chanel LaShawn Batts. Chanel LaShawn Batts. Last call for Chanel LaShawn Batts. An arrest warrant will issue.
Pat's in the courtroom?
Is she in the courtroom?
No, Judge, sorry.
Okay. Travis Bess, that case is paid in full. Nyla Cannon. Nyla Cannon. Nyla Cannon. An arrest warrant will issue. Morian DeVell Claiborne. Morian DeVell Claiborne. Morian DeVell Claiborne. An arrest warrant will issue. Ashley Kiera Clark. Ashley Kiera Clark. Ashley Kiera Clark. An arrest warrant will issue. I'm sorry. Hello? All right. Arrest warrant will issue. Shannon Monique Coleman.
I'm here.
All right, Ms. Coleman, it looks like you've made some payments. The court is going to put you in a breakout room with Ms. Powell so that you can speak with her and she can explain the situation and the possibility of getting an additional modification, okay?
Okay, thank you.
All right, Ms. Powell, I'm going to set up breakout room number 2 for you and the individuals who are going to go into that breakout room, but I'll start putting them in as I'm calling them, okay?
Yes, ma'am.
All right, you all, the invitation will be on your screen. If you activate your screen, you'll be able to go into the breakout room through the invitation. Michael Pierre Dillard. Michael Pierre Dillard. Last call from Michael Pierre Dillard. An arrest warrant will issue. Candace Nicole Edwards. Candace Nicole Edwards. Last call for Candace Nicole Edwards. An arrest warrant will issue. Tisha Urell Gardner. Tisha Urell Gardner.
Judge, she's present in the courtroom.
All right. Ms. Gardner, when Ms. Powell is finished with the individuals in the video, then she will have the opportunity. When I'm finished, I'll put you in a breakout room with her, okay? Hawkins, Shania, Ayana Hawkins. Shania, okay. Ms. Hawkins is on video?
Yeah. Yes, I'm sorry.
Okay. All right, Zalandria Henry. Zalandria Henry. Last call for Zalandria Henry. An arrest warrant will issue. Antonio Rodriguez Johnson. Antonio Rodriguez Johnson. Antonio Rodriguez Johnson, arrest warrant will issue. Malik Lavelle Jones. Malik Lavelle Jones. Malik Lavelle Jones, an arrest warrant will issue. Felicia Nikita Kennedy. Felicia Nikita Kennedy.
I'm here.
All right. I'll put you in a breakout room with okay, ma'am, it's helpful if you put your first and last name on the screen. I don't know everybody, so telling me your name is Felicia is not helpful to me. I might have 6 Felicias on a calendar. I'll put you in a breakout room with Ms. Powell. Daniel Leno. Daniel Leno. Last call for Daniel Leno. An arrest warrant will issue. Detricia Lewis. Detricia Chukwu Lewis. I think that fine has been taken care of. So Maisha Tambrea Love.
Present.
All right. Miss Love, I'll put you in a breakout room with Miss Powell.
So what do I do? Just go to the the other screen?
Yeah, once the breakout room opens, you'll see an invitation pop up. So right now it's closed. When I open it up, everybody will get their invitation to go in,
And just
okay?
turn my camera back off and my mic.
You what?
Just turn my camera and my mic back off for now.
Yeah, that's fine.
Okay.
Tari LaRon McBride, Tari McBride. Last call for Tari or McBride. An arrest warrant will issue. Tashara McCoy. Tashara McCoy. Last call for Tashara McCoy. An arrest warrant will issue. Hanson Mentor.
Here.
All right. Is that Zoom user?
What was that?
Okay, Mr. Mentor, I need your first and last name on the screen. I'm going to put you in the breakout room. When I open the doors, you'll see your invitation, okay?
Okay.
All right. And next is Haley Gabrielle Miller. Haley Miller. Haley Gabrielle Miller. Arrest warrant. Alexis Patrick. Alexis Patrick. Alexis Patrick. Arrest warrant. All right. So for the individuals who will be speaking with Ms. Powell, with the exception of one person, I believe that's Ms. Gardner, everybody is in the breakout room. I'm going to open the doors. When you see the invitation, go into the breakout room and you can discuss your case with Ms. Powell. Please make sure you give her your email address before you come back to the main room so that she can send you the court's decision. Okay? All right. So the breakout room is open. You can go into the breakout room if you see your invitation. All right. Now, give me 3 minutes to breathe and I'll be right back.
Do we have time to use the restroom?
Let's take a comfort break. We'll be back in about 7, 8, 10 minutes.
Okay. Thank you.
All right. Thank you. All right, is Ms. Bing back?
Yes, I'm back. Sorry.
Your
No
Honor,
problem. Yes,
I have an announcement.
yes.
Judge, we're going to withdraw the motion at this time.
Okay, and this is Ms. Walker.
Yeah, Tanya Walker.
All right. And let's see, did we have one more motion? I thought I heard something about an immunity motion.
Judge, that was no process if you're referencing Ms. Parker.
Oh, okay, that was Ms. Parker. All right, so what do we have left on this calendar? I have that Barnett was no prost, Johnson no prost, McEachin was the modification is granted with the court's direction. Parker was no prost. Polk. We have
She's in the courtroom, Judge.
yeah. Ms. Polk, this was the one where we had to determine whether we're able to modify the sentence. I think this is another one of those where I may have lost the ability to do that because too many terms of court have passed, but we will get you an order and we'll send it to the address where that's on the motion. So the situation is not that the court doesn't want to assist, but comes a time when if you haven't moved for a modification within a certain amount of time, the court loses the ability, the jurisdiction over the case in order to change things. Okay, so we'll look at your order and then, we'll look at your motion and then we'll do an order consistent with the law. Okay. All right.
She is.
Because I came here on November 20th.
Come on up. I can't hear you, ma'am.
You're from the court, not me. No.
Yes, ma'am.
Hi, Your Honor. I was before you and I was to pay $500 restitution, but when I checked with the insurance company, they said that the case had been settled. She did not have to pay $500 deductible. They waived that and they had already sent her a check.
Okay, so I ordered you to pay the $500 and you wanted that modified? Because if it's been satisfied, then the court, I'm not holding you on anything outstanding, am I?
Well, it was a $500 plus I had a ticket and you reduced it to I think like 80 something dollars.
Yeah, well, if you've paid everything or if it's been satisfied, the case is closed. I don't really need to modify the sentence as long as what I ordered to happen happened.
Oh, I don't know how.
Whether you did it or whether the insurance company did it, it doesn't matter to me.
Yeah, the insurance company did it, and so I didn't want to have to pay double.
No, ma'am.
Okay, well, I was trying to get clarification. I came 3 times here to the court.
Okay, so what you can do is the paperwork that you have, you can take a copy of it and you can file it with the clerk's office with your case. So you'll just tell them that you wanted to file paperwork with the clerk's office to go with the case. And so if anybody's looking for it, there will be information that the $500 was satisfied. But I did not receive anything that indicated to me that you did not complete the sentence.
Okay, I brought the photocopy from Allstate that the claim had been paid, and I wrote you a letter on November the 20th.
Well, see, that's the thing. I can't see information that y'all just write directly to me because that's called ex parte communication. The way that you communicate with the court is either through the state's attorney, a defense attorney, or through the clerk's office. So if you file something with the clerk's office, it is open to everybody who has access to the case. It is not just me. And so when you send me a letter or you email me something, I'm not allowed to look at that. And a lot of times people don't understand. You can't talk to me directly. It's not because I think so much of myself. It's the way the court and the judicial system is set up. I can't have any communication with you about what's going on with your case without including the other parties that need to have the same information. Okay. So what I'm asking you to do is, like I said, I have had no indication that you did not complete your sentence. For everything that I know, your sentence is complete and you've done everything that the court asked you to do. If you want to make sure that this is not going to come up at any other time, you can file a copy of the information from Allstate with the state court clerk's office downstairs on the first floor, and you would just give them your name. They'll look up the case number and they'll file it in with the other information that they have about the case.
Okay, and I did that on November 20th, so you want me to go back down and check?
No, if you've already done it, then like I said, what triggers me to act if somebody tells me you did not do something or you did something or you're making a request. You've made a request to modify your sentence, but there's really no need to because you've satisfactorily completed the sentence.
Okay, so, but I did not pay the fine for that you gave me.
Ma'am, I don't care how the fine was paid as long as it was paid. And generally, when we have a discussion about it, I will always say, if your insurance company or somebody else has paid what was necessary, then just bring that information to the court.
But the
We're not going to come
$87
looking for you for the other $500 is what I'm trying to tell you.
Yeah, well, I want to pay the ticket that was $80-some. Okay, the screen went blank.
Then you can go down the hall on the second floor. When you come back through the double doors, go to your left. When you go to your left down the hall, is it going to? Yeah, when you come through the double doors, go to your left, go down to the traffic court window, and you can pay your ticket.
Okay. Thank you, Your Honor.
You're welcome. All right.
Was that Miss Gardner, Judge?
No, that was Miss Polk.
Okay, for the 11 o'clock motions calendar?
Yes.
Got it.
All right. All right. Have you spoken with everybody for the modification?
Yes, I have. So essentially everybody that I spoke with did accept a modification. However, Miss Felicia, she may not be on the call because her phone died. She should be joining again, but we'll make a note that her modification was supposed to be for $100, not $153. When she took her plea, that was the deal that she worked out with the prosecutor.
Oh, okay.
I did check CPUA, and it does say that the suspended sentence fine is $100.
Okay, but the $100 is the base fine. It's $151.50 with the surcharges. Was she not aware of the surcharges?
I believe she was not, Judge.
Okay, well then that is what includes the surcharges.
Understood. So the 100, Miss Kennedy is on the call now. Miss Kennedy, your $100 was the base agreement that you made to pay with the prosecutor, but the $53 reflects the surcharges that's added for basically like the court having or the courthouse having to process your fine.
And the surcharges that are imposed by the state. So whenever I sentence someone, I always say these things because I don't want y'all to have sticker shock.
Miss Kennedy,
I was never told that because they told me that ticket is $153. That's how much that ticket costs. So when I spoke to the prosecutor, I said, because first of all, I wasn't even supposed to be on that calendar. They never submitted to the P. Diddy. So I actually went up there and because I got the letter in the mail and I wasn't even on the calendar. So I went there, got the ticket, went to the clerk office, and he said, look, I reduced it to you for $100 because of that. That's what happened. They ain't saying nothing about no 150 because it was originally 150.
Miss Kennedy, the point is that the fine could have been more than $153.
No, that's a $150 ticket.
Miss Kennedy, I'll reflect that in the modification. I'll look at the information between you and the prosecutor, and we'll if it's required, I'll reflect that in the modification.
Yes, ma'am. I'll wait.
All right. So, Ms. Powell, so for these individuals, you have given them the 2-week information. Shannon Coleman, Janiyah Hawkins.
Yes, ma'am.
Felicia Kennedy.
Did you say Shania Hawkins?
I'm calling names, ma'am. I'm trying to confirm with Ms. Staff Attorney. Maisha Love.
Felicia, you can be there, sorry.
And ladies and gentlemen, listen, I'm talking to my staff attorney. I'm trying to confirm that she's spoken with each of you. You don't have to answer. I'm not calling your name to speak to you. And Hanson Mentor. Is
Yes,
that
ma'am.
correct? Okay.
Yes.
And Ms. Gardner, if you will come up to the front for me.
Your Honor, can myself and Attorney Lynch be excused? I believe we've concluded all our business before you. Thank you, Your Honor.
Welcome. All right, Ms. Gardner, you're before the court for the amount of $738. You failed to pay, and this is since September 4th of 2025. So you will only be able to receive 2 weeks modification.
Okay. Is it possible I could put some money on it today?
Yes, ma'am. That would probably be your best bet.
Okay.
You can put some money on it today, tomorrow, every day until it's due.
Okay.
All right. So yeah, because ladies and gentlemen, we give you more than enough time. If I say 60 days in court, by the time you get to this process, you've had a year. So it doesn't make any sense to not take the time that was given. I tell people put a reminder in their phone. Nobody does it. And so then people get arrested every day because they owe anywhere from $100 to $1,000 because they didn't pay attention when I said put a reminder in your phone so you don't miss the deadline. All right. So I'm going to give you 2 weeks to pay. You'll give me your email address, ma'am.
YARRELL80@gmail.com.
I have YARRELL80@gmail.
Yes, ma'am.
All right. So you'll get the modification in the mail. And then once you get, you don't have to wait for the modification. You can go today. But for all of you who have had your sentences modified, your payments do have to be made in person because you've lost the ability to pay online or by phone by missing the deadline. Okay?
Okay.
All right. Thank you, ma'am. You're free to go. You can go down the hall on the second floor and pay that now.
Okay, thank you. So you said I could put
Right.
some money on it, or
I'm sorry.
I can put some money on it, or I have to pay the whole thing?
You can put some money on it. The whole thing is due in 2 weeks, but you can put as much money on it today as you can.
Yes, ma'am. Okay.
All right. Thank you. All right. So ladies and gentlemen, my
I'm sorry,
last,
before we move forward, did you want Ms. Yarrow to bring her receipt back up for the order to reflect the updated amount, or do you just want the order to say 738?
no, the order can say the 730.
Yes, ma'am.
All right. All right, so the next thing is the last calendar of the day, the civil red light crossing guard calendar. For these are individuals who received a ticket for an automatic process. Either it's alleged that you ran a stop sign from a school bus, or that you ran a light that was controlled by cameras, and you received the information in the mail. All right. So the first case on the calendar is Velma Gore Albert. All right. Come on up, Miss Albert.
I wouldn't even be listening to all that. Like, I was turning the volume down.
Miss Davis, I can hear you, ma'am. Ladies and gentlemen, I see you. So, but if I hear you while I'm talking to somebody else, it is a distraction. So I just ask that you mute your device. Okay. All right. Miss Albert, you have a red light citation. You have the opportunity to speak with the state, possibly look at your video. And if you all can come to an agreement, that's fine. If not, then I can review the video myself to make a determination. Okay.
I do want you to see the video because that was the whole idea. Because as I was traveling down
Okay, Miss Bing, if we can get the investigator to queue up Miss Albert's video, I'll look at that.
Okay.
Judge, did you complete the motion to suppress from the 11 o'clock calendar? I believe it was Ms. Walker.
It was withdrawn.
Yes, ma'am.
All right, so we'll be looking at Miss Alberts. Miss Albert, if you just have a seat further up towards the front in the courtroom, so when your case, when it comes up, I can just call you back up.
Okay, thank you.
All right, next is Sakalia Latrell Anthony. Sakalia Latrell Anthony. Last call for Anthony. All right, that motion will be dismissed and the fine will be paid. Maddie Faye Appling.
Yes, ma'am, I'm here.
Where's Miss Appling?
Right here.
Oh, okay, it's under Faye Keen.
Yes, ma'am, sorry.
All right. So Ms. Keen, did you wish to have the court review your video, or did you wish to speak with the state to determine whether you all could come to an agreement?
No, it's fine. I don't know if I don't remember the date if I did it or not. I probably, maybe was rushing one day. I'm not sure, going to work or something, but it's fine. However we can come to agreement, I'm okay with it.
Okay, so this is, I'll let you speak with the state. This is a crossing guard, which means it was a bus. And ladies and gentlemen, the bus citations are $1,000. That's in the law. I can't modify it. I can either determine that you didn't do it, and that's a zero, or it's $1,000 if you did do it. They don't give me any leeway about modifying those citations. So if you wish to speak with the state, you may, but if not, I can look at the video and determine whether it's a violation or not.
Okay, this is
All
a
right.
school bus, like a elementary?
Yes, ma'am. The state legislature in last year or the year before made a determination that too many people were running bus stop signs, and there was a catastrophic case in, I believe, Athens, Clark County, where a teenager or 20-something lady ran around the school bus and ended up killing the child that was getting off the school bus. And so because of that, and because of the number of incidents that there had been, the state legislature took it into consideration and made it a hard $1,000 fine for anybody who would run a school stop sign, a school bus
Okay, I
stop.
thought it was like a red light, not a school bus.
Okay, so yours says crossing guard. We can look at it and see which it is.
Okay, because the letter that I had got, it said traffic light. It didn't
Okay.
say school bus.
All right, it just says crossing guard on my notes. So
Okay.
you can review that with the state, and then if it's a crossing guard, that's different. I mean, if it's a red light, that's different.
Okay.
All right. All right, so you can review that with the state. Next is Ryan Estevan Barclay. Ryan Estevan Barclay. Last call for Barclay. All right, this appeal will be dismissed. Wakitha Bird. Wakitha Bird. BYRD. Last call for Wakitha Bird.
I'm here, I'm just trying to get to you.
Okay, come on up. All right, so Ms. Bird, you can talk to the state, or I can look at your video and make a determination. What would you like?
I can talk to them because.
All right.
So where do I go?
All righty. Just have a seat closer to the front. Miss Bing, are you going to walk down at some point? Did you want to do it, or did you wish to have your how do you want to do it?
I thought it was going to be a breakout room.
Oh, that's fine. I can do that.
Okay.
All right. Shante Crawford. Shante Crawford. Last call for Crawford. All right, the appeal will be dismissed. Danita Marie Cummings. Danita Marie Cummings. Danita Marie Cummings.
I'm here.
Your Honor, we've already looked at that video. We're gonna, we've agreed to grant that
Hello?
appeal.
Okay, so Ms. Cummings, your appeal will be granted and you're free to go at this time.
Okay. Yes, ma'am. Thank
All
you.
right, thank you.
Okay. Bye-bye.
All right,
Good.
Amelia Smith Davis.
Hang it up.
Amelia Smith Davis is here.
All right, so Ms. Davis. Has the state reviewed this already?
Yes, the state's reviewed everything, all of the
Okay.
cases. Mhm.
So Ms. Davis, did you wish to speak with the state or did you wish to have me look at the video?
Well, I wasn't driving, Your Honor. And I
Okay.
filled out an affidavit last year. I filled out an affidavit with the person who was driving and
Okay.
sent it in, but I don't have a copy of it.
Ms. Bing, did you all receive her affidavit?
Don't have that, with her file. I can certainly inquire. I think that I'll have, I'll see if Lauren can find something.
All right, so Ms. Davis, what I'm gonna do is continue your case so that you can submit the affidavit. I'm sorry that somehow it went missing, but I'll continue your case for you to allow you to submit the affidavit again.
Okay, what does the continue?
Meaning that we won't hear it today. We'll wait until they receive the affidavit.
Okay.
Your Honor, I'm
All right.
sorry. Did Miss Davis,
Hold on.
did she send it directly to a prosecutor, perhaps Mr. Tipton?
Ms. Davis, do you know
I have the notice of the citation right here.
Yes.
And I went to UPS and I sent it to where it says make payment processing center, Clayton County, Georgia, Seattle. Clayton County, Georgia, Payment Processing Center, P.O. Box, Seattle, Washington,
Send it out to the
98124.
main place?
And that was last year,
I
probably in
got you.
May.
So they may have not sent the information with her case. Yeah. So Miss Davis, what I'm gonna do is I'm gonna allow you to submit the affidavit directly to Clayton County.
Mm-hmm.
All right, Miss.
If she wants to hang on, I can give her my info.
Yeah.
Is that okay?
So if you just hold on, Miss Davis, Miss Bing is gonna probably chat her information to you so that you can send it directly to her.
Okay.
All right, just hold on for me so we can get that information to you.
Okay, so I need to get another affidavit certified.
Yeah, unfortunately, sometimes when you send it out to Seattle, which is supposed to be the processing point, they don't send it this way. And I would rather you go ahead and get the affidavit done, which is a whole lot cheaper than if it's $1,000 fine.
Okay.
All right, so just hold on for me.
Okay.
All righty. All right, the next case is Carl Wesley Davis. Okay, Mr. Davis, come on up.
Pardon me, Ms. Davis, I just sent you a chat, so take a look, okay?
All right.
Okay.
So, Mr. Davis, you're before the court for the red light ticket, a speeding ticket. So did you wish to look at that, or did you wish to talk with Ms. Bing about that, or did you wish to have the court review it?
Well, I don't know the process, but I got 2 tickets, right? One in December 2022.
Mm-hmm.
And then we got another one in October 2025. They were both $80.
This one was filed November 12th of 2025, so this is probably the October ticket.
Yes, and I was driving on both of these tickets. And I was guilty and did not.
Okay, hold on. Who's speaking?
My wife, Michelle. Here, you gotta get in front of the camera.
Oh, sorry.
Oh, all right.
I was driving both times, and the one in October, I acknowledged that I was at fault
Paid 80.
and I paid the $80. But
Okay.
prior to that, I got a school zone camera ticket in December of 2022. And my dash cam showed that the school light wasn't flashing when I went through it, but it was flashing.
Okay. Miss Davis, it's a little simpler than that. All we need is the affidavit that Mr. Davis wasn't driving.
No, both our names are on the card.
Both of our names are on the
Okay, so
card.
your name is also on it? Because I don't
Yes.
have it on my calendar.
Yes, it's with both of us.
Okay, so you
But
want me to
we
look at the
went to-
video is what you're saying?
Yes, we
All
thought
right.
that. We contested that ticket in 2022 because we appealed it because I knew I wasn't guilty for that one. I had a dash cam to prove that.
Okay.
We went to pay the ticket in November for the most recent one. They charged for both tickets without ever even giving us a court date for 3 years.
Okay.
And we want our $80 back from that ticket we're not guilty of because we can prove.
Okay, Miss Davis, I'll look at the video and we'll determine whether you get your $80 back. Okay.
Okay, well,
We have
is
pictures here.
it a whole video? Because the time from the
Miss
flashing
Davis,
speeds.
Miss Davis, I won't know until we look at the video. I'm just calling the calendar right now. All I know now is you need me to review the video, but I can't have a full hearing right now because I'm just trying to call the calendar and determine what you need to do.
So when you call the calendar,
I'm doing that
you need
now.
to see the flashing light before the ticket and after the ticket.
This is in
Okay.
2022.
And it is in December of 2022.
Okay.
We just never got a court date.
But we've already paid it.
So,
because
and we have already paid
when
it.
we went to pay
because
it sucked out.
It just sucked
I'm
it out.
clear, Mr. Davis, Miss Davis. I'm clear. I'm just, okay, this is what I'm saying, and I'm trying not to be rude. Y'all keep talking, and I have enough information to move forward with what I need to do. If you have a seat closer to the front, I'm gonna call you back up and we'll get all of this sorted out. I know you had two tickets. One of them you paid for, you admit guilt, the other one you did not.
Correct.
All right, have a seat for me. All right, next is LaShundra Myra Gaston. LaShundra Myra Gaston. Mr. Florio, did I miss something on one of our calendars?
No, ma'am. I'm doing a favor for a young lady that's coming up on this calendar.
Oh, I was going to say, because you don't usually appear on this calendar.
No, her. It's Nigel Hunter's mama is coming up, and so I'm doing her a favor.
Oh Lord. Okay. So Miss Gaston. Okay. So the appeal will be dismissed for Gaston. Ashay Goldson. Ashay Goldson. Miss Goldson is coming up. So ladies and gentlemen, on my calendar, and this is why I'm asking the questions, because on my calendar, even if you don't remember, it designates whether it's a crossing guard ticket, which is a bus ticket, or a red light ticket. So if I'm looking down and it says crossing guard, that's different from going through a red light. So that means that you went around a bus stop sign. So that's when I say crossing guard, that's generally what that means. Yes, Miss Gaston? I mean, Miss Goldson, I'm sorry.
Yes, Your Honor. Yes, I was here to contest, the incident. First of all, it's, I'm actually a teacher for the Clayton County, for this system, I guess, where this is located.
Okay, so do you know that it was a bus, or you need me to look at the video to determine that?
Well, I've seen the video from the.
Okay, all right, so let me look at the video, and then, because essentially what you're arguing is not going to make sense to me until I see the video.
Okay, and it's 5:18 in the evening as well.
Okay, gotcha.
Okay. Do you need me to sit down?
Yes, ma'am.
Thank you, Your Honor.
You're welcome. And then Courtney Williams Hamlin, Courtney Hamlin.
I'm here. Hello.
All right, Ms. Hamlin, you have a crossing guard 1-2, which is a bus. Do you want me to look at the video or do you wish to have a conversation with the state?
Would you mind explaining what would be the difference between you looking at the video and me having the conversation with the state?
Well, sometimes the state has already looked at the video and they're willing to dismiss it, or they're going to explain to you why they're not willing to dismiss it, and y'all can agree on terms. Otherwise, I can just look at it and make a determination. It really is you're up to you.
Okay, I'll speak with the state.
I'm sorry?
I'll speak with the state.
Okay.
Okay.
All right. Next is Kasaya Aliyah Hodo. Kasaya Hodo. All right. Okay, so I have two people standing in front of me.
The ticket was issued to me, but my dad was driving.
Okay, your dad was driving?
Yes, ma'am.
Okay, then your dad needs to fill out an affidavit.
Okay.
So how do we do an affidavit?
Yeah, you have to do an affidavit to assert that she was not the one who was operating. So one of you needs to do an affidavit to assert that she was not the operator of the vehicle. I'll give you a continuance so that you can do that and submit it. Miss Bing is going to give you the information where it should be submitted. So Miss Bing, if you want to send, I guess, Miss Arnold or an investigator or somebody to give them the information where they need to send the affidavit. Okay, if y'all have a seat, we'll get that done, okay? Vanessa Hunter.
Good afternoon, Judge. Ms. Hunter's my client. If
All
I could
right.
have a pretrial with Ms. Bing, please.
Okay. All right, so next is Regina Yvette Johnson.
Yes.
All right, Ms. Johnson, I have a crossing guard violation for you also. Did you wish to have me just look at the video, or did you want to talk to the state about it, or were you not driving?
I do want you to review the video, but I want to explain as well, or should I talk with the state?
Okay.
Oh, I'm sorry, Your Honor, I want to grant this appeal. I'm so sorry.
Okay. So, Ms. Johnson, the appeal is granted and you're free to go at this time.
And what do I do now after? Yeah, I'll
You
wait
good?
for a letter.
No, you're done. It's finished.
Okay. Oh, all right. Thank you.
All right. All right. Then next is Jerry Farika Knight.
I'm here.
All right, come on up, Ms. Knight. All right, so I've gone through the calendar, which gives the state time to queue up the video. So we'll go in order when I go back through. Ms. Knight, good afternoon.
Hi.
Did you wish to speak with the state, or did you wish me to look at your video? This is a crossing guard, which means a bus ticket.
I did submit an affidavit stating that I was not driving.
Okay, Ms. Bing, did you all receive that affidavit?
I don't believe so. Let me check with Lauren though.
Okay.
And mine was sent to a processing center as well.
Oh,
yeah,
okay,
I
we
think
don't have it.
This one was for Arizona.
Oh,
I
boy.
I got her to do two, so I have.
You have a copy of it? Oh, good.
Okay.
So she has it in court with her.
Okay. I'm going to send someone down to grab that.
Okay, so she's gonna just have a seat. She's gonna send somebody down to get a copy. There's a copy machine in the courtroom if you need to make yourself a copy before she takes that one.
Thank you.
And are
You're
you going
welcome.
to view the video once they get it?
No, because if she wasn't driving, I don't have to look at the video. I can't proceed against her if she wasn't driving.
So I'm the one that was driving. What
Well,
do I
you
do
just
now?
admitted that you didn't have to, but the ticket that was before me is only about her. I can't proceed on a ticket that's not before me.
Okay.
Sometimes you can, you know, people don't understand the right to remain silent.
Look, I'm silent. I didn't hear
We
anything.
all have a Fifth Amendment right to remain silent, and what we don't use it.
What the world? Thank you, Your Honor.
All right, so have a seat for me. All right, last case is Sean Kelvin Ware. Sean Kelvin Ware. Last call for Ware, Sean Kelvin Ware. So that appeal is going to be dismissed. All right, so
I have the video teed up for the one that you wanted.
yes, sir. So Albert is first, and hi.
Hello, Your Honor.
Hi, Deputy Castro. I haven't seen you all day, but I know you've been in there.
Hi, Your Honor.
All right, so Miss Albert's case.
Now, I'm Miss Polk.
You're Miss Polk?
Actually went down to the state clerk and they sent her back up here.
I went to the traffic.
Oh, I'm sorry. Yes, ma'am.
Yes, I went to the traffic court on the second floor to pay
Yes, ma'am.
the traffic ticket, a part
Yes,
of the
ma'am.
restitution. And they said they don't have an order from you, so they can't take my $70-something.
Did you already pay it?
No. It was a part of the restitution. I'm supposed to pay $100 a month.
No, ma'am. The fines and fees and the restitution are separate.
No, the probation paper put it all together.
Okay.
That's why I did the modification, because I didn't want to pay the Ms. Chang told me that the first $500 that would go to restitution. And I said, well, I'm applying to have it modified, and I just pay the ticket. So nothing has been resolved because I came to.
All right. Let me ask this, Miss Wright. Who is Miss Rodriguez or Miss Wright?
It's me. It's Miss Wright.
Oh, okay. Miss Wright, Miss Polk. She's on I believe she's on the motions calendar for the 11 o'clock motions calendar. Shirley Downing Polk 2024 TK 27244. If you can determine what's been paid and what hasn't been paid on that, I would really appreciate it.
Okay, give me a moment.
Thank you.
Yeah, nothing has been paid.
She is correct. Nothing has been paid.
Is there a way to reactivate the sentence so that she can, or do I need to modify her sentence so that she can pay the $73 or $83 or whatever it is?
You can do an order as a modification order to remove the restitution, and that will.
All right, Ms.
That will do
Powell,
it.
can you do me a modification ordering that the restitution has been paid, and therefore the only outstanding amount is the fines and fees that were ordered to be paid?
And you
Yes, ma'am. Is that like basically just that language, no numbers?
And supervision fees were waived.
Yes.
Okay, so restitution has been paid, supervision fees waived, and the only remaining
How
amount.
much is the amount, Ms. Polk?
Oh, the screen went blank.
No, what did you? Oh,
excuse
go
me.
ahead, Ms. Wright.
The fine was $50. The other fees made it a total of $74.
Okay, so it'll be $74, Ms. Polk. Miss Powell is gonna modify it, and she's gonna as soon as I sign it, as soon as she does that, she'll send it to me. I'll sign it electronically, and you can head down and pay it, okay?
Okay, but you waived the fee, Your Honor.
No, I waive the supervision fees for probation. That's
Oh, okay.
$50 a month. I cannot waive the county, the fees that the county has to pay to the state that go with every base fine.
Okay, I understand that.
Yes, ma'am.
Okay, Judge, I'm gonna send it to you right now. If it needs to be tweaked, just let me know.
Just go ahead and send it to me.
Your Honor, may I just say something really fast? And please don't get mad at me if I'm wrong.
I'm not.
I just want to make sure that before Ms. Polk leaves, that she is in the condition that she wants to be when she leaves
Right.
here.
I got you.
When Ms. Polk, when I read your motion, and correct me if I misunderstood, it sounded as if you had paid the $500 restitution and then found out that that restitution was not proper because the victim never paid that deductible and that you wanted that back. Am I understanding that correctly?
No.
Okay, got you.
Yeah, I think what happened was the insurance verified that they paid it and it didn't rise to the amount of $500.
Gotcha.
And so she didn't want to still have to be responsible for the $500 as well as the fines and fees.
Okay.
So this will allow her to just pay the $74. But yeah,
Okay.
I get it because it was confusing to me too.
Thank you so much.
No problem. You know, I'll fuss now, but I'm on, you asking a good question. I'm gonna go with the question.
Okay.
All right. So,
Okay, wait, Judge, I know you're ready to move on. How's this? The above stout matter having come before the court, defendant is hereby ordered to pay $74 in outstanding fines and fees. Like, just very simple. That's it.
Yep.
Okay, I'm sending it. I'm saving it and sending it.
And Judge, when you've signed that, if you can send that to Tiffany and or Rachel, they're the ones that are going to need that.
Okay.
Thank you.
Sorry, do I also need to go see Miss Chang?
No, Ms. Chang is out of the process at this point.
Okay, thank you.
You're welcome. She'll get a copy of the order if she needs it, but yeah, she doesn't have to, you don't have to go see her. Okay, so Ms. Polk, it'll pop up in a moment. As soon as I sign it, I'll tell you and you can head out downstairs to go ahead and do it.
Okay, thank you so much.
Okay, so just have a seat and I'll let you know in a minute, okay?
Thank you.
Hey, Miss Arnold.
Hi, Judge Hayward. For those who needed to fill out the affidavit, are they free to go?
Yes, ma'am, as long as you got what you need.
Okay, thank you.
All right, thank you. So anybody who had to fill out an affidavit, as long as you've already talked to Miss Arnold and she got what she needed on behalf of the state, then you're free to go. All right. Okay, I'm ready for the videos.
Okay.
And just tell me who I'm looking at. And I'm ready to go.
Okay, this is going to appear on my screen. Let me know if you can see it.
Is this Miss Albert?
This is Miss Albert. Mm-hmm.
Okay, all right.
And you can see that, right?
I can. Well, with the help of taking off these progressives.
Well, let me hear. That good?
Yeah, that's perfect. Oh, yeah, that's
Okay.
much better.
Okay, here we go.
Oh, I know where this is. Okay, go ahead.
Okay, I thought I hit play. Hold on.
It's not, yeah.
It's not playing.
Take it back to the beginning because it looks like some part of it is already.
Okay.
Let's see if it'll go from there. Okay, it's buffering.
Okay. Let me see if it plays better in the All right, let me re-queue it. I'm sorry. Give me 1 second. All right, let's try again. Here we go. Can you see that, Judge?
I see it. Okay, there was a red light, a red turning light, but it looks like they're turning and the light is red.
Mm-hmm.
And it was steady red even
Mhm.
before they got to the intersection.
Yes. Shall I
go
play
back
it again?
Yeah. Okay.
Okay.
All right. So the red light, when you hit the arrow at the turning at the turning lane before you even cross the guideline, when you hit the arrow at the turning lane, that's when the light when it became red, but it was a steady yellow prior to that.
Exactly. I sent in an affidavit of non-responsibility explaining exactly what happened. You can't hear the horn that the truck driver did behind me. That was the reason why I kept going, because he was blowing the horn so loud that, in my opinion, if I didn't keep going, he was going to rear end me. That's
Yeah,
the
but
reason why.
y'all were in separate lanes.
Okay, ma'am. I
Okay.
understand what you're saying, but I didn't think that I could get over before he could hit me. So I just made a decision to say, I'm not gonna allow him to rear end me. That was the reason why I got out of his way.
Okay, but you weren't in his way until you put yourself in his way. So what I'm looking at is y'all are in parallel lanes. He's in the far left turning lane. You're in the closer left turning lane. He's behind you. And as you're turning, you turned almost in front of him, which like if you had stopped or slowed down, you would have never had the issue of coming into contact with him at all.
No, if that's how you are seeing it, what I felt at the time with that horn that loud and looking in my rearview mirror, I just felt I had to get out of the way. So that's fine if that's the determination.
Yes, ma'am.
Where do I go from here?
Then you can the fines and fees. What's the standard fine? $80, isn't it, Miss Bing?
We generally say $100, but I'm happy to say 80. It's fine.
80 is fine. And then, ma'am, is this something they have to pay online through the portal, or can they pay at the
Yes,
they pay it?
They can pay online at violationinfo.com. Ms. Albert, you have a copy of your ticket?
And it says amount due 70, so you're adding additional.
Okay, well, I'll do with the 70. That's fine.
Okay, am I able to pay it from here?
It is better if you pay it through the portal.
Okay. I know where that is, but okay.
It's on your ticket. If not, we can get you more information about that, but it should be on your ticket.
Okay, I do have the ticket in my hand. All right, thank you.
You're welcome, ma'am. Miss Powell, can you resend it to me and just add that the restitution has been satisfied?
Yes, ma'am. One moment.
Right after fees, put restitution has been satisfied. I'll try to do it myself, but it's not working.
Yep, I can do it. I'll send it right
All
back
right.
over.
Thank you. All right, and then I'll sign that for Ms. Polk. Okay, so the next case.
The next one that you you want to look at? Do you want to do that? Okay. That's Mr. Davis.
Yeah.
I thought it was Miss Appling.
That wanted the judge to see the video?
No, Miss Appling's Miss who's also under Faye Keen. She said she'll
Yeah.
talk with the state.
Well, I mean, if you can you look at it? Can we look at it?
Yeah,
Okay,
you
that's fine
can
with
pull
me.
up Miss Appling. I don't care. Yeah.
Okay, well, I'm sorry, Mr. Davis is already in front of you if you wanna.
Oh, okay.
Yeah, that's fine.
Okay.
I don't mind looking at them. That's not a problem for me. I just want everybody to be on the same page. If it's a bus ticket and I find that you had the opportunity to stop and you did not, then it's $1,000 and I have nothing to do with the $1,000. So,
Right, I understand.
okay.
Let's cue this up.
Video. 2022. The camera.
Oh, sorry, you know what? This is a different. Excuse me.
Be the 1011. 1011.
Okay, so.
Last 4 digits. 1011. That's it.
All right.
Did
So
they
this
say
was
that-
a speeding, I believe this was a red speeding ticket.
Okay.
So just to note, this is a school right here.
Yep, that's over by
On 138.
oh yeah, the elementary school. Yeah, on Kendrick, off of Kendrick Road.
Okay. So the speed limit is 25. So you can. I was on the fence about it, but that's him.
Can I just tell you that I was caught in between two flashing lights. I specifically looked at that light going into that school zone because I knew that the school zone was sometime around then, but they don't post the times.
Now they
It just says school zone when flashing. The speed limit on that road is 45 and my ticket was for 47. But I got my ticket at 1:44 and like 19 seconds or 30 seconds.
Okay, can I look at the video?
Sure. And the light doesn't.
Miss Davis, stop talking.
Okay.
Can I look at the video?
Are you able to see it, Judge?
Yeah, go ahead and play it.
That's it. It's just a loop.
No, I'm just looking at the picture. There's no video.
That is the video. You don't see it?
No, I see the picture of the citation where it shows click here to play video and then the picture of her passing the elementary school and then the tag.
Let me.
So it's not running video yet.
Okay. Let me try again. Do you see video now?
No, every time you click on it, it's not clicking. It's like there's no hyperlink.
Huh. Okay. Let me.
It's a camera. It's not a video. It's a camera. It's one of those.
No, it says click here to play video, and I've been.
It might just be the school camera. This might be the only image.
No,
but
I'm looking at it. I'm looking at it move.
Oh, okay. Well, yeah, it's not moving for me.
Okay, let me try to come out for a second.
Okay, it's still up on my screen.
It's come up on your screen.
Yeah, so it's still as a page. Okay, here we go. Maybe this will help. Try it again. Yeah, it's not. It's just a page that's showing the
Okay. Well, nevertheless, that's why it's a pop out.
Exactly.
Okay.
And I would just like to say that I had a dash cam on my vehicle.
Give me 1 second.
Took pictures. One picture, the light's not on going into the school zone, but it's on as I'm coming out of the school zone.
Okay.
I got caught between two lights.
Okay.
I think I figured it out here. Hold on. I think I figured this out. Hold on, give me one quick second. This is, but even still, just so you know, Your Honor, even if you can't see it, she's already
Okay.
said that it was going 47. She was going
I got
47 and
you.
20. Yeah.
Which regularly it is for 45 regularly, and it goes down to 25 for the school zone. I've had this issue happen before, and it was right at the time. 145 is right about the time they turn the flashing lights on, because that's when they get ready for dismissals in the elementary school. So they'll turn the lights on, the flashing lights, right around 145. So you said it was off when you entered the speed zone area, and it was on by the time you exited. You would have been going. You would have been gone pretty much within the speed limit had both lights been off as you ascertained it. I'm going to go ahead and ask and grant your appeal. The citation will be dismissed. You'll be able to get the information to go to the clerk's office to get refund of the fines and fees that were paid. So what I want to do is, Ms. Bing, if you'll just go ahead in the order, just put that the court, after review by the court, the court determined that that there was no violation, and that any monies paid with respect to this citation should be returned.
Well, thank you.
You're welcome.
Thank you.
We've already paid 3 tickets. We're not even speeding.
Okay, well, I'm gonna need y'all to slow down, because if y'all get to the point where
I
they
know, but
keep,
we didn't pay this. I mean, we learned the lessons from this.
I got you. So I need y'all to slow down.
Yeah.
Especially in a school zone. Sometimes it's better, even if you don't know when the lights come on, to slow down as much as you can.
I specifically looked at that light.
I got you, but you're right in between, and it's at 145 that they turn the lights on.
They should post the signs, because we don't have kids.
I got you.
We don't know the times.
The reason I know is because I do have kids, and my son used to go to the next elementary school right past that. So I got you.
We go down to the second floor? Or
no, the first thing you're going to do is you're going to get your modification. You're going to get the order from Ms. Bing. So what I need from you is your email address. And if Deputy Castro can just give you a piece of paper so that you can write that down, Ms. Bing will send you by email the order after I have signed it, and then you can petition to the court clerk's office to have refund of the amount. So if I could get it all done today and save you a trip back down here, I would, but that's not how this works. And so what I'll ask you to do is you can contact the state court clerk's office. You can go on their website, or you can call them to find out the best way to get refund of the amount. The order will be filed with the clerk's office, so they'll be able to see my order.
Great, thank you.
Okay.
You're welcome.
Miss Arnold should be coming down to get your information.
Okay, so Miss Arnold from the solicitor's office is going to come down and get your information if you have a seat for me.
Okay.
All
Judge,
right.
Can we
Yes.
check the chat real quick?
Yes.
It'll come down to the information for it.
Yeah.
Okay. Yeah, that's fine.
Okay.
All right, and I'm ready whenever the next one is up.
Goldson. I have a note here saying that she wanted. I'm sorry, Miss Keene, did you have something to say?
Yeah, I thought I was next after him.
Oh, I'm so sorry. You might be. Hold on. I'm so sorry. 1 second.
Miss Keynes is under a different name.
Oh.
Maddie Faye Appling, that's my government name.
Okay.
Okay.
Sorry, it's just my Gmail is faking. Sorry.
Okay. I have a note that you want a conference, but are we just letting the judge see these?
Yeah, she just wants to skip. Go ahead to that.
All right. Let me just cue it up.
Cause I'm confused.
Okay, I'm going to share my screen.
All right, the modification has been done, Ms. Polk. You can go ahead and go on downstairs, and I did send it to Ms. Jeffers and Ms. Jones.
Thank you.
Okay. Your Honor, I just want to confirm that you can see this page.
I can see the page, and I can see that it just switched to the video.
Okay.
Mm-hmm.
There we go. So this is the school bus.
Okay.
And
Where am
there
I?
she goes.
All right, run it back.
Now, what car was that? Because I have a Mazda 3 2011. That's a whole different car. That's not my car.
Okay, let's see here.
I have a Mazda 3 2011. It's black. That looks like a whole different model car. That's not mine.
Cadillac DeVille?
No, ma'am. That's not my car.
Under Appling?
No, that's not mine. That's actually that Cadillac was actually that was actually I went ahead and sold put that into someone else's name. He's
Ooh.
actually my cousin. My cousin's name is Sherman. That's
Okay,
not my
well,
car.
I'll grant the
Yeah.
appeal because same thing happened to somebody I know. They sold their car, and before
Yeah,
the
I sold it, and he went and put that
yeah.
into his name. So I don't know why it's not showing up in the DMV system. Yeah, that's not my car. That's why I was confused on what's going on.
Well, this is a third-party processor, so it may not have transferred by the time that they got the information. They might not have had the most update to information. I'll go ahead and grant it because that did
Okay,
look like
so
an old school
Yeah, I'm like,
Cadillac.
I can show
Yeah,
you guys my car right here. I have a
no,
Mazda 3
I could
black.
tell. I could tell from the lights.
Yeah, I'm like, I'm sorry, that's not me.
No, I
But yeah, but
so
we've
we'll go
already
ahead.
I've been signed that off months ago. So I don't know why it's still in my name.
Well, you may have signed it off, but he may not have turned in the paperwork to transfer it over.
We
What I would
went to the we
okay,
signed it off, and then he had went to the DMV that same day. So
he
I don't
went.
know what happened. Yes, ma'am.
Okay, so you need to check. Just call the DMV and ask for a list of the vehicles that are in your name, okay? Because
Okay, so
sometimes
does this
people will
mean
say they went, but they didn't.
okay, so
So the
what do
case
I
is over. You're finished.
okay.
Just
Okay,
breathe.
so I'm good.
Because you all
Okay,
on
thank
10,
you.
and I'm gonna need you to come down to like 2. So
Thank
the
you,
next
because
thing
my
you need to
anxiety was
do
up.
is just verify that this car has been taken out of your name. And if it hasn't, they'll have a form at the DMV for you to do that.
Okay.
Hold on just a second. I have access to an expert. Let me find out.
Okay.
Something like that happened to me. I had sold the car for the first time, didn't know what I was really doing. I didn't take the tags off, and I kind of trusted them to put the tag, like to take the tag off, switch it off, put it in their own name, but they didn't. So they ended
Yeah, but
up getting a
the
ticket.
tag and everything is under his name and everything.
So,
It's not even, yeah, that's
okay.
why I'm like,
Miss
I don't understand what's going on.
Miss Keen.
Yes,
So
ma'am.
this is what an expert told me. You need to go to your local tag office.
Okay.
They will look it up by the tag name, by the tag information, and by your information, and they will verify whether it's still in your name and where
Okay.
where it's located. Okay.
Okay. Yes, ma'am.
All right. Did you get your tag back?
Mine's?
Yeah. When you sold the car, did you get your tag that off the car?
No, I
Okay,
didn't,
that's all
but
you
he,
need to, well, wait. That's all you need
okay,
to
I'm
tell
sorry.
me. You need to go
Okay.
to the tag office and verify that it was transferred.
Okay. Yes, ma'am.
All
Thank
right.
you.
You're welcome.
Okay.
Bye.
Bye.
Next.
I think Bird is next.
Okay.
Junior, nigga.
Oh,
I'm sorry.
Y'all gotta mute, cause before y'all, if I say y'all are done, get off as quickly as you can. I'm hearing too much. All right, so who's next?
Bird, I'm queuing up now. Sharing my screen.
Okay.
Just confirm that you can see that.
I can.
Okay. Make that big.
Okay.
Here we go.
All right.
There she goes.
The gray or the green or the
No, that one, that black one, that last Nissan, that black last car.
Okay, do it. Go ahead.
Mhm. That one.
Okay. Yeah. That's pretty clear, Miss Bird.
Yes, ma'am.
I'm sorry.
I said, yes, ma'am.
Okay. Yeah, that was pretty clear. And this is always my indicator. The newer buses, especially, but even some of the older ones, they start flashing yellow lights. And when they pull over, even if you don't see a red sign, I stop, because once the red sign comes out and you're still moving, you're not going to be able to stop because of the flow of traffic or the speed at which you're going. So once they pull over, and I've had this happen where I'll pull over, I'll stop, and they'll wave me around because they're not putting the light out. But otherwise, if you see them pull over, if you see them stop, then you got to stop. And even though two cars flowed past, that third car means that you had time to appreciate that it was stopped, that the light was out, because two cars flowed past you before you came by.
Yes, ma'am.
Okay. So now what I can do is we can give you 90 days in which to pay.
Okay. That's
All
the
right.
longest I can have, 90 days, okay.
Yes, ma'am. So I'll give you an order from the state. They're going to do the orders and I'll sign them and we'll send them through to you by email. So if you could chat your email address, I'm sorry, write your email address down or give it to Miss Arnold, who might be in the courtroom. And then we'll send it to you, and it'll be modified so that you'll have 90 days to pay, and you can pay it through the portal.
Okay, thank you so very much.
All right, please be careful.
Yes, ma'am.
Okay, who's next?
Next one is Goldson. Am I still sharing?
Yeah, I see it.
Okay.
Okay, it's a silver Honda Civic.
Yes.
All right, let's go. Yeah, two cars passed. Was the silver Honda Civic one of those? Or is this the one I'm looking at now?
Yes, I believe it was the second one.
Well, 5 cars passed already. Here's the problem.
Can I say
People
something?
think that because it's a divided highway, they don't have to stop. But the only time you don't have to stop for a bus sign is if there's a barrier in the median that would mean a car could not cross into the median. So if it's trees, plants, if there's a built up barrier, like those cement barriers, if it's something where it is not, you can't drive into that part of the median. If you can drive across the separation in the road, then you still got to stop.
It was that first one.
It was 518, Your Honor.
What's that mean? You mean you don't think they drop off kids after 5? I'm sorry, I'm trying to understand. So the timing doesn't matter because it has the same weight legally as if you passed a stop sign that was stationary. So the fact that it was 518, I'm not sure what you're trying to make that mean.
Okay.
No. I mean, is there some, because if there's something legally that I need to consider, but the timing if it's a school bus, imagine even if you got kids coming from a after school event that is school sponsored, if they have to be dropped off somewhere and the bus has to pull over and put the sign out, this is a stop sign.
I get it.
Okay. So yeah. All right. I'll give you 90 days to pay. Please leave your email address so we can get that information to you and you can pay through the portal.
Do you take credit card?
You can't get anything, but
Okay, then I can pay it today.
I believe so. Yes, ma'am. I think they'll take it.
Okay. And where should I pay, ma'am?
You'll pay through the information that's on your citation into that portal.
Oh, okay.
Yeah.
So I can't pay here in person?
No, ma'am.
All right. Okay, thank you.
You're welcome. All right. So the last case that I guess I hadn't had an opportunity to look at is Miss Hunter.
There's a Hamlin on here.
Hold on. I see Hamlin. Hold on. Oh, yeah. We can look at Hamlin. Is this Hamlin?
Yes.
Okay. Right. This is also a bus ticket. Ladies and gentlemen, I'm so close because I had to take my glasses off to see mid-range because I have progressives. So this is the best way for me to see the whole picture. Go ahead. Ooh, yeah. Who's the SUV?
Yes.
Go ahead. Yeah, the bus was already stopped. That's a close one.
Yes, and were you done?
Yeah, go ahead, ma'am. Go ahead.
Oh, okay. I don't know if you can see, but right behind me, that sign, that's where I had just began my new employment, and it's the Clayton County of Water Authority. So I was actually making a right out onto the highway. So I missed the yellow lights, the red lights. I didn't see any of that. And then by the time the stop sign came out, that they left, little time to make a stop.
Yeah. Okay. So you were turning when the stop sign came out. I'll give you the benefit of the doubt on that one. So we'll go ahead and grant the appeal. But now you know that's a stop sign. That's a bus stop.
Ma'am. I am. Look, every bus I see, I am on the brake, getting ready to stop. So
I have been there. So yeah, every bus I see, I stop.
Yes, and I have learned from now on moving forward to do so as well. So
Okay.
thank you.
All right, ma'am.
Okay.
Thank you. Yeah, I'll just a minute until y'all can come back with an announcement on Hunter.
I also see one for night.
Knight is submitting an affidavit.
Thank you.
Judge, can you please confirm you dismissed or released rather Miss Felicia Kennedy earlier with the rest of the SSD folks, right? We're going to look at what's in the record and make a determination on the final count.
Yes, ma'am.
Miss Kennedy, you can exit the call.
Thank you very much.
Yes, ma'am.
Hello? I guess we might be on mute.
You're not muted. Just wait one moment for the judge to return.
Oh, thank you.
Ms. Polk, I sent the order. What's the problem?
I went to pay it and she said she couldn't take my money because she doesn't have the order. It's the
I
third.
sent it. Miss Wright, did you get it? Because I sent it.
And I e-filed it as well.
Yes,
it's-
I saw it.
Miss Wright, can you tell them that, you know what, at this point, I'm willing to amend it to where you don't have to pay anything. I'm done. Yeah, give me an amended order, Miss Powell, that the court is going to suspend the amount.
Yes, ma'am.
All right,
So
just amend
$0 owed.
Yeah, just put it
Okay.
amended at the top and then modify the one I just did, and then I'll sign it.
Yes, ma'am.
All right, thank you. All right, Ms. Polk, you're good. I'm gonna send that in a minute.
Okay, and I'll be able to get a copy of that
Yes, ma'am.
from downstairs?
If you give me about 10 minutes.
Okay, I'll go back downstairs. Thank you so much.
You're welcome. All right, we have something on Miss Hunter.
I didn't realize I was on mute. I've been talking the whole time. Were you able to see anything, Your Honor?
I didn't see, which clip are we running? That's what I'm looking for.
For Ms.
Who is this?
Hunter?
Okay, no, I hadn't seen anything.
Okay, I was trying to share it and for some reason it wasn't cooperating. So let me.
I see the share, just the first page, but I don't have the video yet.
Okay, give me 1 second. So you can't see that, or you can see that?
I see the same thing. I don't see the
This?
video.
Okay,
Yeah.
sorry.
There we go. Okay.
All right.
All right. Okay.
And that's her.
Oh, Lord. Is this a one-way street?
It looks like it's a neighborhood. I don't know. It looks wide enough to be 2 ways, but it looks residential.
All right. Mr. Florio? Is Mr. Florio still on?
I'll try to text him and see.
Was that the beginning that it played from?
Yes, ma'am.
Oh, boy. Sure is. Yeah. Where's Mr. Florio?
I text him. I don't know where he is. He's always multitasking. So I don't know if you want to come back.
Yeah, I'm ready on that one. It looks like that's gonna be one where we have to give you 90 days to pay. Well, that's our last case. So if we can get Mr. Florio back, we'll be done for the day.
Let me try to give him a call.
Judge, while Miss Bing is working on that, can we step into a breakout room briefly so I don't have to hold you after court? I also sent over the order for Polk.
Ms. Powell?
Yes, ma'am.
Okay, send that to Miss Jeffers, Rachel Jeffers, Tiffany Jones, Amanda Wright.
Okay.
Thank you. And yeah, we can go into a breakout room because I was trying to wait for Mr. Florio to get back.
Judge, I'm gonna have a copy of the new order for Miss Polk printed and at the front desk if she wants to pick up a copy.
All right, Ms. Polk, when you go downstairs to the first floor, the clerk's office, then they'll have a copy of my amended order waiting for you, and it shows you don't have to pay anything and you're free to go. And sorry for the confusion.
Sure, already went down there, Your Honor.
Okay, thank you. Yeah, I'm gonna go into the breakout room, Ms. Powell. I'll go into breakout room number 2 where you already are.
Okay.
Hey, Stephanie, can you and I talk about
Yeah,
the case?
yeah. Did you want to look at the video really fast? Because it's up right now. Can you see it?
Sure. Yes, ma'am.
All right, let me show you. You want me to replay it or no?
Wait, where is it playing? I'm sorry, I didn't see it.
Oh, I shared my screen, but let me, I'll stop and share again. Give me 1 second. Do you see that?
Okay, yes, ma'am.
Okay, let's see.
And
And um And in order to get to a breakout room, I don't know if someone else other than the judge can take us there. But judge did say she was ready to make a ruling.
I think only the judge and Miss Powell can, and they're the ones in the breakout room.
Y'all want to call each other on the phone while y'all wait on judge?
I'm sorry?
Do you want to call each other on the phone while you wait on judge?
Great idea. Let's do that.
I'll call you right now, Stephanie.
Oh, okay, thanks.
All right, Mr. Florio.
Yeah, we were just about to call each other because I guess he wanted to discuss something. I did let him see the video and let him know that you were that you were ready to rule, but I think he still wants to chat.
Okay, Mr. Florio, did you still wish to speak with Ms. Bing?
Yes, ma'am, if I could, please.
Sure, I'll put you in a breakout room.
Thank you, Judge.
All right, Ms. Bing is in breakout room number 1, so I'll add you, Mr. Florio. All right.
Medication, right? It's the medication just wrong. So
Your Honor, may we please have a pretrial conference with the court?
which next Monday's a holiday. Okay.
Hello?
Meditations would make.
You need me to come into the breakout room?
Yes, ma'am, please.
All right, I'm joining.
Miss Wright, is it Tiffany Jones, Miss Tiffany Jones that needs to order as well?
Yes, ma'am.
Okay, I'm sending that now. I just e-filed it.
Thank you.
And we're going to connect you with a mentor that's going to help you all get ready.
All right. So, ladies and gentlemen, thank you all for your patience. I think this has been a long process for a lot of you. I think we have everything resolved. The Hunter case is going to be continued. So that'll go on the calendar. Everything else, I think we have made a decision on. And at this point, if you're going to receive an order from the court, you should receive that by email. So we'll talk to you later. Thank you. All right.
All right. Have a good day, Judge. Thanks so
All right,
much.
everybody, take care.
Wait,
Thanks for
wait, wait, wait. Continued till when?
I don't have a continuous date yet. We'll just put it on the next available calendar.
Okay.